Pass over item number 4.
Single static authorization. Court must be simple. Yes. Take instruction in this matter and counsel.
No, the child is the custody of the father.
Father,
This
the
case is maintainable.
the manner in which he has taken. So if he is well and good, it's all right. Just take instruction how the child is there, but because it is mentioned that forcibly she was taken and
Last occasion, my lord directed the petitioner counsel to take instruction. Some cases has been filed, divorce case and other matters have been filed before the different courts, my lord. So what is the status of that kind? Regarding that, my lord, it was adjourned to today, my lord.
no, we'll take up this matter next week because she
My
is
lord.
not there. We cannot
My lord.
just obtain instruction how the child is now there. If it is well and good, she is staying happily. That
Yes.
then because as for the first information report, instruction from the take down non appears on behalf of the petitioner. The land council for the state shall obtain instruction in the matter. Out of this matter, we commencing from 19th February 2024. Yes, next case.
Item 9.
May I please? My lord, the present petitioner is inside the jail custody since 12/12/2011. As he has been convicted and sentenced for the offence under section 302, 307 and 34 of IPC. And the present appellant now is the appellant number 4, Rega Chattar.
My lord, in last occasion in the other cases, my lord. This is the order, my lord.
This interim application is filed for which appellant?
My lord, appellant number 4.
That is Rega
Rega
Chattar.
Chattar, my lord.
And when he is in custody?
My lord, 12/12/2011. More than 12 years.
He was never released on interim bail,
No, my lord.
either in the trial court or before this court.
No. My lord, since then he is inside the jail custody.
What do you say, Mr.
Yes, madam. He stands in the same footing of the appellant note 2, madam.
2, my lord.
Okay. IA number 3072 of 2023 is an application for bail filed by appellant number 4, Rega Chattar. Is it Rega or Raga Chattar?
Raga.
Rega.
RAGA.
RAGA.
RAGA, Raga Chattar. Learned counsel for the petitioner submits that the petitioner is in judicial custody since 12/12/2011, and as such, he has suffered incarceration for a period of more than 12 years. And the paperwork has not been prepared, and therefore there is no chance of early hearing of the appeal in the near future. He further submits that appellant number 2, Kataram Purti alias Katia, has been released on bail by this court. In IA number 2169 of 2023 as per order dated 30/10/2023. And the petitioner is similarly situated. Therefore, the bail application may be favorably considered. Copy of the bail order of the appellant number 2 is produced, which is taken on record. And counsel for the state, after verification of the evidence adduced by the prosecution during trial court, in the trial court, doesn't dispute that the petitioner is similarly situated like appellant number 2, Kataram Purti alias Katia. Considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody, release of the co-accused bracket appellant number 2 on bail, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail. Allowed.
Blessed.
Item 10.
Item 10, I'm sorry, I couldn't be present when the matter was earlier called. And there was a confusion whether the file belongs to me. In fact, I have verified the file is of our office, but unfortunately, I have not been able to trace the file. It's a disposed of case where application for modification has been filed. I'm praying if your lordship will be kind enough to take it next week, and I can assist your lordship, because post facto the order there has been some development which I have to bring to your lordship's kind notice also. I pray may be taken up next week, my lord.
The only modification you want is the plot number.
My lord.
So the case was disposed of by us on 7/1/2020.
My lord.
So there was some direction. So in the meantime, 4 years have passed.
My lord.
So whether you want to praise this interim application for modification or will dispose of simply?
That will be necessary. I had mentioned Maybe because of constitution of proper bench, the matter could not be listed, and it has come now, my lord, before lordship. I'm only praying since I have not been able to. The file is with me, but lordship may
You
pardon
want
me.
it next week?
I'm only praying for next week so that I can assist your lordship.
Let Mr. Samir Kumar Mishra, Land Counsel, appearing for the petitioner, seeks for an adjournment till next week. Put up this matter next week. Yes.
Right, obliged.
Item 20 में पे,
Hmm?
20.
Yes. Hmm.
Item 20. May I please, your lordship? Although this is a jail criminal appeal, but the appellant privately engaged Mr. Lakshminarayan Patel through prisoner's petition. So, my lord, on behalf of Mr. Lakshminarayan Patel, I may be permitted to submit.
What is your good name?
Agni Shikha Rai.
No, Ellen Patel has been privately engaged by the.
Yes, sir.
My lord.
Then you can ask for the reason. So it's a case of sole appellant.
My lord.
Found guilty under section 302.
My lord, 302 and 201 of the IPC.
What sentence has been
My
imposed
lord,
by?
for the offense alleged under section 302, he is sentenced to undergo RI for life and to pay fine of rupees 5,000 in default to further undergo RI for 3 months, and convicted for the offense alleged under section 201, who sentenced for 1 year and pay fine of rupees 1,000 in default to go 1 month more in prison, rigorous in prison.
Okay.
My lord.
Come to the first information report. Let us
Mine.
see what.
14 minute, page 14.
Married. My
Yes.
मेरा नाम विजय बांद्रा, उम्र 25 साल, पिता मांगता बांद्रा, निवासी डूंगा.
Who is that informant? PW?
My lord, informant is not examined.
Okay. Yes.
My lord. निवासी डूंगा कुचरा, थाना डुमरिया, जिला पूर्व सिंहम, झारखंड. हाँ, मुझ झुंपड़ी पड़ा, CWS कॉलोनी, हल्ला बेलपहाड़, जिला झारसुगुड़ा. मैं वही रिपोर्ट दर्ज कर रहा हूँ कि मैं RCCP में हेल्पर काम कर रहा हूँ. करीबी 1 महीना पहले मेरा भांजा मोटका पूर्ति, उम्र करीबी 23 साल, पिता पोगड़ा पूर्ति.
That Motka Purti is the deceased in this case,
My-
right?
My lord.
Okay. Continue.
पिता पोगड़ा पूर्ति, पूर्व सिंहम, झारखंड से मैं यहाँ नौकरी दिलाने के लिए साथ में लाया था. हम लोग उनका फोटो के साथ बाकी कागजात RCCP कंपनी में दाखिल दिए थे. उनका नौकरी पक्का होने वाला था. यहाँ रहते रहते मेरा भांजा हमारा पड़ोस प्रधन बोंद्रा के साथ दोस्ती हो गए थे.
Pardhan is the appellant.
माय लॉर्ड.
Okay.
वो दोनों मिलकर घूम रहे थे. गया 10 तारीख दिन करीब 12 बजे मेरा भांजा मोटका उनका दोस्त प्रधन बोंद्रो के साथ कहीं निकल रहा था. जब मैं पूछा तो जवाब दिया कि प्रधन के साथ चिड़िया मारने के लिए जंगल जा रहा हूँ. साथ में मेरा कलेबर ही ले गया था. प्रधन की बाएं हाथ में लाल रंग का इलेक्ट्रिक तार था. वे दोनों के साथ हमारा पड़ाका एक 10 साल का बच्चा भी था, जिसका नाम गाजी साइवा में ड्यूटी चला गया।
PW4 factory.
मैं ड्यूटी चला गया। शाम को जब मैं लौटा तो देखा प्रधान, उनका बीवी रानी पूर्ति और वो छोटा बच्चा नाला में मछली मार के पाड़ा वापस आ रहे थे। मेरा भांजा ना घर में था ना इनके साथ था। इसीलिए मैं प्रधान को मेरा भांजा के बारे में पूछा तो वो बोलने लगा कि मोटका वो गोड़पड़ा में छोड़ दिया, पर मेरा भांजा को घर नहीं लौटा। हम लोग इधर उधर ढूंढ रहे थे। आज सुबह तक कोई खबर नहीं था। आज करीब 10:30 बजे खबर मिला कि एक अनजान आदमी का लाश CW कॉलोनी के पास लिल्लारी नाला में पड़ा हुआ है। मैं वहां जाके देखा तो कुछ पुलिस वालों ने उस लाश को पानी से उठा के जांच कर रहे हैं। मैं लाश के पास जाके अच्छी तरह से पहचाना। वही लाश मेरा भांजा मोटका पूर्ति का बोल के पुलिस को बताया। पुलिस अपना कार्रवाई करके पूछा, घटना के बारे में पूछा तो मैं शुरू से जो हुआ था बताया। लाश सड़ गया था, फिर भी मैं उनका शर्ट पैंट और चेहरा देख के बाद मुझे पहचानने में कोई दिक्कत नहीं हुआ। उसका जीभ बाहर की ओर निकला हुआ था। कमर और घुटनों में प्लास्टिक इलेक्ट्रिक का तार के द्वारा 2 पत्थर बंधा हुआ था। सिर का पीछे चोट था। गला में फूला वो आ गया था। ये सब कुछ देखने के बाद मुझे पूरी तरह से महसूस हो रहा था कि मेरा भांजा को मार दिया गया। हत्यारी मेरा भांजा को मर्डर करके उनका कमर और घुटना में पत्थर बांध के लाश को छुपाने के लिए नाले के पानी में डाल दिया। मैं इस हत्याकांड में प्रधान बोंद्रा को पूरा शक करता हूँ। पढ़ के सुना देने से मेरे कहने का मुताबिक सही लिखा हुआ जानकर दस्तखत दिया। उसका एक नकल मुफ्त में प्राप्त किया।
Okay, is it a case based on direct evidence or it's a
Direct evidence.
direct evidence?
One
Who
sole
is the eyewitness?
PW4.
The child witness.
Okay, PW4, and what are the other?
Extrajudicial confession is there.
Just a minute.
PW6. before.
Extrajudicial confession before PW6.
Yes.
Right.
Any other material?
Mhm.
Last scene
Last
there.
in
leading to discovery.
leading to discovery is there.
What was recovered at the instance of the appellant?
That plastic rope ଯୋଉଟା ବନ୍ଧା ହେଇଥିଲା ତା ଲାଶରେ
Who has stated about that?
During course of investigation, police.
No.
Right.
Whose evidence is relevant for that point leading to discovery? Apart from IO, who is the investigating officer?
IO is
PW7.
PW7 is the IO.
Right.
Yes.
Any independent witness examined?
No.
So one is eyewitness, second is the extrajudicial confession, third is leading to discovery, right? So these are all the material. Okay. By the way, what is the cause of death as per the PM doctor is?
PM doctor is PW3.
3.
Yes.
So let us come to that first. Let
Three.
us see what is the cause of death.
Right.
Please place the PM doctor
Right.
evidence.
On 12/4/2004, I was in my present post. On that day at 4:15 p.m., on police requisition, I conducted the postmortem examination of Mutka Purti, son of Buguda Purti, and found fracture of occipital bone of size 2 inch into 1.5 inch. The injury was antemertum in nature. The age of injury within 72 hours prior to my PM examination. The injury might have been caused by hard and blunt object. On dissection, I found the corresponding injury to the fracture of the occipital bone was laceration of brain. No other internal injury was found. The cause of death was due to hypovolemic volumic shock due to intracranial bleeding and cerebral anesthesia due to profuse bleeding. The injury was sufficient in ordinary course of nature to cause death. This is my report, Exhibit 3 and 1 is my signature.
Yes, then
I also examined the stone sent along with the dead body and opined that the injury on the deceased could be possible by hitting with this stone. MO1 is the said stone and MO2 is the copperware with which the knee joints were tied. Exhibit 4 is my opinion report and 4 and 1 is my signature. Cross examination. I have not mentioned that the dead body was already bloated. I have only mentioned that the dead body was swollen. I have not mentioned the condition of the nails of the fingers. Since the dead body was swollen, the question wrinkle does not arise. I also do not find any wound on the body of the deceased. I did not find any undigested food in stomach. The stomach was totally empty. The deceased might have not taken any food at least 4 hours prior to his death. The tongue might be protrude due to excessive pressure of gas present in gastrointestinal tract even after the death. Bulging of eyes and protrusion of tongue could also cause due to strangulation and asphyxia. The second query of the IO was not required to answer in view of findings in my postmortem examination. I have not put any specific mark on MO1. It is not a fact that I have not mentioned in my PM examination report that the death could ordinarily be caused by hitting with MO1. Such death of deceased cannot be possible by strangulation or by asphyxia.
okay. So now you come to the eyewitness account
Four.
against
My lord,
PW4.
PW4. My lord, PW4 is a minor. So the witness is a child witness. I asked some general questions and he has clear understanding and gave rational answer. He has no understanding as to the duty of speaking oath and hence no oath is administered.
Right.
I know, the statement. I know the accused and also the deceased. About 1.5 years back in the afternoon, I myself, the accused, and the deceased had been to the backside of our colony towards Lillari Nala for bird hunting. The deceased was going ahead, followed by the accused and myself. Near the Nala, the accused hit the deceased on the backside of his head by the stone. As a result, the deceased fell down. The accused then again hit the deceased on the same place. Seeing this, when I started running out of fear, the accused threatened me to kill. If,
Yes.
My-
Yes.
threatened me to kill if I go away from the place. The accused thereafter tied a stone on the chest and waist of the deceased by the wire and threw him in the Nala. It was a red color wire. MO2 is the said wire. We returned back to our house after taking bath. The accused warned me not to disclose it to anyone and threatened me to kill. MO1 is the said stone. Cross examination. I do not know where I have come. I just accompanied my father. I do not know if police has come to my house 3 to 4 days ago asking us to come to the court today. I was going for bird hunting with Gullar in my native place. I have never come to jungle after coming to reside at Jhumpudi Pada. Prior to my working in the cycle shop, about 1 year back, I was engaged in grazing cattle. I know the accused as he reside in our basti. I know the name of the deceased and his maternal uncle's name. His name is Vijay Bandra. I cannot say the types of dresses worn by the accused and the deceased. The accused was having a cloth bag. I cannot say its color. The accused was holding a gullar. He had put the cloth bag inside his pocket. It is not a fact that I did not accompany the accused and the deceased towards Lillarinala. We were going towards the Lillarinala in a single line, one after the other, and an intervening distance of about 3 to 4 feet. The accused hit the deceased in the nala. There was no one except we three. MO2 is the stone by which the accused hits the deceased. The deceased has already reached the nala and the accused going down gradient hit the deceased by means of the stone. As soon as the deceased was hit by the stone, blood came out. Some blood also fell on the stone. It is not a fact that the deceased fell down backwards while going down the ridge and the accused did not hit him by MO2. It is not a fact that the deceased fell on the stone. As a result, blood came out and he died. I am disclosing this fact for the first time today. I did not disclose to anyone as the accused had threatened me. I was examined by police. It is not a fact that there was no such occurrence that I am deposing falsely, since my father and myself were threatened by police to depose.
What is the date of occurrence?
My lord, if date of occurrence is 12, last thing that
Yes.
if 12 pray, they are with this person. 12 is the FI date. 10,
That is 10th.
10th is the occurrence date. 12 is
10
FI.
4 2004 is the occurrence date.
My
In
lord,
between, you say 2 a.m. to p.m., right?
my lord.
That is in the FIR. And the FIR was lost on
12.
12/4/2004, right?
My lord.
So when this eyewitness, this child witness was examined,
On 12.
Yeah. No, my lord.
yes,
He was on the 5th day of October 2005.
My lord, ask for that.
please find out that 161 statement. Let us see when this Gardi Sham was examined. His name is Gardi Samna
Gardi Sayan.
Sayan.
Sayam.
SAYAN. Sayan.
एक बाहर करो देव. Gardi Sayan is date of examination is 12/4/2004. The date on which the affair was lost.
Yes.
My lord.
Yes, sir. Deposed in the court in 5th October 5.
Stated in his affair,
He was not examined.
but he was not examined at that where
Hey,
but is not known.
paper book. You come to the affair once again.
My lord.
The first page, last 4 lines.
My lord. गया 10 तारीख दिन करीबी 12 बजे मेरा भांजा मोटका उनका दोस्त प्रधान बोंद्र के साथ कहीं निकल रहा था. जब मैं पूछा जवाब दिया कि प्रधान के साथ चिड़िया मारने के लिए जंगल जा
Just
रहा.
a minute. Just 10th at about 12 o'clock, the deceased, along with his friend, that is the appellant, they had been to jungle, right?
My lord.
So what the informant says, when I asked the deceased, who was his nephew, as to where you are going, the answer was that we are going
Bird hunting.
for bird hunting, right?
My
Yes.
साथ में मेरा
Caliber.
कैलिपर ही ले गए थे. प्रधान की बाएं हाथ में लाल रंग का इलेक्ट्रिक तार था. वो दोनों साथ हमारा पड़ा के एक 10 साल का बच्चा भी था जिसका नाम गार्जी. Okay, that is there. So this PW force presence has been stated in the company of the deceased and the accused in the first information report itself. Okay, so if we come to the evidence of that eyewitness, which is a child witness, so the deceased was going ahead, followed by the accused and myself. So this boy was in the backside, right?
My lord.
Near the nala, the accused hit the deceased on the backside of the head with a stone. As a result of the deceased fell down, the deceased then again hit with the same place. Seeing this, I started running out of fear. Accused threatened to kill. I towed to sponsor accused thereafter. So, Mr. Tripathi,
Yes, my lord.
this particular line which he has stated in paragraph number 3 of the cross-examination, page 34,
Yes, my lord.
that I did not disclose to anyone as the accused had threatened me. So, how the police came to know that this boy is an eyewitness to the occurrence? When the accused was arrested,
My lord, accused arrested on 25/7/2004.
so how do you challenge the evidence of this
My
PW4? What is your submission?
My lord, PW4, the occurrence took place on 10. PW4 examined on 12.
Right.
Within these 2 days, he never, that part is not in the evidence that he disclosed this fact to his father and mother, that his father mother has not examined.
Mhm. Where he has stated that he disclosed to father, mother.
Not stated. So his father mother must
Rather,
be.
he has stated that I have never disclosed this fact to anybody.
My lord.
Right.
My
The FIR was lodged. If we'll come to the FIR once again,
My
So after the dead body was recovered from that,
Nala.
right, then this man came to know and he
Right.
went there.
Right.
मैं लाश के पास जाके अच्छी तरह से पहचाना,
Right.
वो लाश मेरा भांजा मोटका पुर्ती का है।
Right.
पुलिस अपना कारोबार करके so let us come to the evidence of that IO. IO is
PW7,
PW7.
page 39.
Right. On 12/4/2004, I was in my present post. On that day, while inquiring into the UD case 1/4, the complainant Vijay Bandra orally reported before me that his nephew Motka Purti had been towards Lillari Nala on 10/4/2004 at 12 noon with his friends. The accused and one boy, namely Gardi Sayan, for birds fruiting. But his nephew had not returned. When the informant inquired from the accused about his nephew, he gave out that he had left Motka Purti at Goudapada. So they searched for his nephew, but could not find him. On 12/4/2004 at 10:30 a.m., he came to know that an unknown dead body was floating in the water of Lillari Nala, and when he went there, identified the dead body to be of his nephew. So he suspected that the accused might have killed his nephew. The oral report of Vijay Bandra was reduced into writing by me, read over and explained to him, and he admitted the contents thereof and signed in my presence. Exhibit 6 is the affair, 6/1 is the signature of the informant Vijay Bandra. On report of one Prafulla Kumar Rai, PW2, that a dead body of an unknown person was floating on the waters of Lillari Nala, I registered UDFR 1 of 2004 and proceeded with the inquiry. I deputed Habildar A. Kerketa to proceed to the spot and to guard the dead body. Command certificate number 50 was issued in this regard after I made SDE number 302. I also proceeded to the spot and found a dead body of an unknown person was floating in the water. I managed to bring out dead body out of the water and found both the knees and waist of the deceased was tied by electric wire and then tied with concrete slab. Exhibit 7 is the command certificate issued to Habildar Kerketa. At that time, Vijay Bandra came, identified the dead body, and lodged the report, as I mentioned above. As the report revealed a cognizable case under Section 302/201 IPC, I treated the same as FIR and took up investigation. I sent the plain paper FIR received at the spot for registration of the case at the PS. Exhibit 6/2 is my endorsement with signature. The ASI Radhesyam Mohanty, who was in charge of PS in my absence, registered PS case number 35 of 2004 under section 302/201 IPC. Exhibit 3/6/3 is the endorsement with signature of ASI Radhesyam Mohanty. Since a case has been registered under section 302/201 IPC, I felt it proper to close the inquiry in the UD case. I thereafter held inquest over the dead body at the spot in presence of witness Prafulla Kumar Rai, PW2, Vijay Bandra, the informant, Suru Bugar, and Jadumani Panchavaya. The result of inquest from the circumstances reveal a case of murder. Accordingly, the witness also myself observed and opined in inquest report Exhibit 2. This is my endorsement 2/2. I thereafter detected Habildar Kerketa under the same command certificate to take the dead body for PM examination. Exhibit 7/1 is my endorsement and simultaneously issued a dead body challan. Exhibit 8 is the copy of the said challan which prepared out of same process, wherein I am requested the CDMO Jharsuguda to conduct postmortem examination. In course of investigation, I searched for the accused and also the boy who accompanied them to forest towards Lillari Nola. In course of search for the accused, I also searched his house situated at a slum area behind the CWS office and recovered 24 feet of red color electric wire and prepared seizure list exhibit 9 in presence of witness Rajendra Rai and Manoj Jaipuria. Exhibit 9 by 1 is my signature. On the same day, I found the boy Gardi Sayan, the boy who accompanied the deceased and the accused towards Lillari Nala, and examined him. The boy was aged about 9 years, and I took precaution to see that the boy gives a statement voluntarily without any fear and influence. I recorded his statement. From his statement, I found that the accused had committed murder of deceased. On the next day at about 5:10 am, Habildar A. Kirketa returned from PM house along with two pieces of red electric wire, two numbers of concrete slabs, and the wearing apparels of the deceased, and produced before me at the PS. I seized the same in presence of Habildar A. Kirketa and two more independent witnesses, Satyajit Oram and Ashok Kisan, and prepared sigil list exhibit 1 1 by 2 is my signature. MO1 is the concrete slab, MO2 is the red color electric wire, MO3 is the pant of the deceased which was on his body at the time of inquest. Exhibit 7 by 2 is the report of Habildar Kerketa on the command certificate on return from the headquarter hospital after the PM examination. I again searched for the accused but could not find him. I visited employer of the accused, verified the attendant register for the months of April 2004 and seized the said register since I found that accused was absent from his duty with effect from 8/4/2004 and had
So
not
absconding is one of the
Yes.
also, right?
and had not resumed till the date of my verification, that is 27/2004. I prepared the seizure list exhibit 5 in presence of witness Chandra Sekhar Rai PW5 and Ajay Kumar Mohoto. Exhibit 5 by 3 is my signature. After the seizure, I gave the said register in Jima of Sribhar Art Singh Beura, in charge of Motor Transport Wing, RCP Junabaga. On 25/7/2004, I conducted raid in the house of the father-in-law of the accused at village Mohanpur and found the accused there. I examined the accused and then arrested him at 4:30 am and forwarded him to court on the same day at 2 p.m. On 10/8/2004, I made a query to doctor who conducted the PM examination to opine if the death could have been caused by assault of MO1, and Dr. White Exhibit 4 reported that death could be caused as a result of assault by MO1. Thereafter, on 28/2004, I made a prayer to the SDJM Jharsuguda to send the material exhibits for chemical examination. Exhibit 10 is the copy of the forwarding letter issued through court to RFSL Ointapalli, Sambalpur. On my requisition, Exhibit 11 is the CE report received in the court. On completion of investigation, I submitted charge sheet on 3/9/2004 against the accused. I have examined Madhusudan Badra. He stated before me that the accused had stated to him that after killing the deceased, he died the dead body with the stone and threw it into the Nala. Cross examination, I received UDFR on 12/4/2004 at 11 am. I have not mentioned the SDE number after receiving the UDFR in my CD. I do not find UDFR in the case record. It is not a fact that Prafulla Rai PW2 did not report to me about floating of a dead body of an unknown person in the Lillari Nala, and for that I have suppressed the UDFR. I have taken steps to tag the UDFR with the case record under intimation to the SDM Jharsuguda. When the dead body was brought out from out of the water, I could see, and I was convinced that it was a case of homicidal death. Thereafter, I conducted the inquest. The case then had turned into a murder case. The informant Vijay Bandra is a witness to the inquest, but he has not endorsed his opinion or suspicion on any person. The inquest was held at 1 p.m. and it was over by 1:40 p.m. The affair was received at 2:15 p.m. The dead body was sent for PM examination at 2:30 p.m. It is a fact that the informant Vijay Bandra did not reflect his suspicion on the accused at the time of conducting inquest over the dead body. My investigation does not reveal that the wife of Vijay Bandra was present at the time of inquest. I have not mentioned in Exhibit 2 in the inquest report in column 7 about the color of the electric wire used in drowning the deceased. I have mentioned that electric rope is used. It is a fact that I have mentioned in column 7 that one stone are used to tie it to the dead body. I have mint concrete slab as stone, though I mentioned in the inquest report regarding other wearing apparels and the articles found on the dead body. I have not seized those things except a full pant of the deceased, as it was not possible to take out of the dead body because of high decomposed. It is a fact that I have not mentioned in the command certificate that the dead body was tied with a stone or slab by means of electric wire and in the same condition sent for PM examination. I have mentioned in the dead body challan that the dead body was tied with stone and slab. The Habildar, while producing the wearing apparels and other articles after the PM examination, has not mentioned the number of wire. It is not a fact that the dead body of Motka Purti, as found during inquest, was not subjected to autopsy by PW3. After conducting the inquest and after sending the dead body for PM examination, I straight proceeded to Jhupri Poda. Jhupri Poda is a walkable distance from the spot where the dead body was found, but I have not mentioned the distance. It is not a fact that no such electric wire was seized from the house of the accused at Jhumpudi. I have mentioned PS case number in the seizure list having obtained over mobile phone. I have not mentioned this fact in my CD. It is a fact that such seizure was made only to implicate the accused on a false case. I have not mentioned in my CD as to where from the accused obtained the electric wire. I have not sent the seized wire from the house of the accused and the seized wire.
Inquest report, just a minute. Just
I-
take pause for a moment. Sincere order. Who is the informant in this case?
Vijay Bandh,
Not examined.
not X. He's the uncle of the deceased.
Why the informant could not be examined?
My lord, as per the judgment, para 6, it stated that the prosecution has examined 7 witnesses. The informant, the uncle of the deceased, and his aunt are not available to be examined, and their whereabouts are not known. It is reported that they had left Jhumpuripada. The prosecution therefore declined to examine them. The informant has only lost the report at the spot when the dead body was recovered by the police from Lilarinala. The affair lost by the informant is only relevant for the purpose of that his nephew had accompanied the accused and a 10-year-old boy, Gaddi Sayan, towards the jungle for bird shooting, and he saw the accused and that boy returning back in the evening without his nephew. Even though the informant has not been examined, it is to be seen whether this part of the story is proved by the prosecution. It is stated in the that the whereabouts are not known and only basing on the FIR. It is
No, this informant is a signatory to the inquest report. First of all, UD case was instituted.
Yes, sir.
When the dead body was found, okay, then the informant was present. In his presence, the inquest report was prepared, and there is nothing in the inquest report that he had any kind of suspicion
Yes.
about the conduct of the appellant, much less to say that they accompanied together to the jungle for bird hunting. Nothing is there, but it is mentioned that ମୁତାଫର ଅଣ୍ଟାରେ ଓ ଗୋଡ଼ରେ ଏକ ଇଲେକ୍ଟ୍ରିକ ତାର ସାହାଯ୍ୟରେ ତାକୁ କିଏ ମାରି ପାଣିରେ ଫିଙ୍ଗି ଦେଇ ଥିବାର ଅନୁମାନ କରାଯାଏ। ଆଉ death of the deceased appears to be due to so and so, but nothing is mentioned, no suspicion. That is how the IO has stated that you come to that IO's evidence.
Can I read that one?
PW7, the lines are,
Therefore, I conducted the inquest.
in the cross-examination, yes, page number 43, paragraph number 7, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12th line from the top of that paragraph, number 7. The informant Vijay Bandra, 43. The informant Vijay Bandra is a witness to the inquest. Vijay Bandra is that informant, right? But he has not endorsed his opinion or suspicion on any person. The inquest was held at 1 p.m. and it was over by 1:40, and the FIR was received at 2:15 p.m. The dead body was sent for PM examination at 2:30. So the inquest was held, and this man who is the informant was very much present, but in the FIR there is no suspicion. Immediately after some time, the FIR has been lodged, wherein it is stated that the appellant is responsible for the death of the deceased, as he had accompanied the deceased and a small child, that is PW4, to the jungle for bird hunting, and last को तार conclusion होची, मुझे महसूस हो रहा है कि मेरा भांजा को मार दिया गया, हत्यारी मेरा भांजा को मर्डर करके उनका कमर और घुटना में पत्थर बांध के लाश को छुपाने के लिए नाल का पानी में डाल दिया। मैं इस हत्याकांड में प्रधान बांद्रा को पूरा शक करता हूं। So this is the FIR. So just a few minutes ago, he was present with the police when the inquest was held. He is a signatory to the inquest report. No suspicion on anybody, much less to say about any appellant. Now he is lodging an FIR. Then the informant has not been examined, so there is no other witness to say that PW4 accompanied the deceased and the appellant to the jungle for bird hunting purpose. Yes. So that means question now crops up that if that child witness, on account of threat given by the appellant after committing the crime not to disclose, he was in a panic state and he did not disclose, then question comes up that how the police came to know that he is an eyewitness to the occurrence. Maybe that that is there in the FIR for which
FIR
right
is there.
FIR is there. So now you are forwarding this FIR, this FIR is dated 12/4/2004, and it reaches the magistrate on 15/4/2004, 3 days after. And the accused, as you said, accused was arrested on 25/7/2004.
4.
So when this 161 CRPC statement of this witness was forwarded to this PW forces 161 of our class epilateral. Underline 12/4. Let us see the case diary. How this short statement 161. मेरा नाम गार्दी साया, उम्र 8 साल। आपके सामने 12/4/2004 को मैं ये बयान दे रहा हूँ कि मैं मेरा माँ बाप के साथ झुपड़ी पड़ा में रहता हूँ और मैं समय समय पर हमारा पड़ा का मोटा का पूर्ति के साथ घूमने जाता हूँ। 9/4/2004 को वर्धन इज दैट अपेलेंट एक नया घर बना के पूजा किया और मेरे को भी वो पूजा पर बुलाया था। 10/4/2004 करीब दिन के 12 बजे हमारा पड़ा का मोटका पूर्ति और पराधन घर से निकल कर आए और मेरे को चल चिड़िया मारने के लिए जाएं ये बोलकर बोले और मैं भी उनके साथ चिड़िया मारने गया। वर्धन एक बैग में इलेक्ट्रिक तार का बंडल रख के हाथ में पकड़ा था। मैं भी एक गुलेस लेके गया था। हम लोग सब मिल के CWS कॉलोनी का पीछे तरफ नाला के पास गए। मोटका पूर्ति आगे आगे चल रहा था, उसका पीछे प्रधान चल रहा था और मैं सबसे पीछे चल रहा था। हम लोग जब सीमेंट चट्टान के पास पहुंचे तो प्रधान गोत्रा पत्थर उठा के मोटका पूर्ति का मुंडी के पीछे के तरफ जोर से किया तो मोटका पूर्ति नीचे गिर गया और प्रधन फिर दोबारा उसी पत्थर को 2 बार मोटका पूर्ति को मुंडी में मारा कि कौन और साथ ही साथ दिया कि वो से मोटका पूर्ति उस उस जगह पर मौत हो गई। मैं सीमेंट की चट्टान पर खड़ा होकर सब कुछ देख रहा था। उसके बाद प्रधन मोटका पूर्ति को पकड़कर पानी के बांध के पास ले गया। फिर वहां से बांध के ऊपर से नीचे पानी के पास लिया ना कौन। उसके बाद प्रधन जो पत्थर मारने के लिए व्यवहार किया था, साथ में और एक पत्थर लेकर लाश के पास आया और मेरे को अपने पास बुलाया और धमकी दी कि अगर तुमने किसी को ये बात बताई तो मैं तुम्हें मार डालूंगा। मैं भी डर के मारे लाश के पास कुछ दूर खड़ा रहा। उसके बाद प्रधन अपने पास रखी हुई बैग से लाल रंग की इलेक्ट्रिक तार निकालकर लाश के कमर और दोनों पैरों को उस पत्थर को बांधकर लाश को गहरे पानी में ढकेल दिया। जिसके स्वांशों में मोटका पूर्ति के लाश पानी के नीचे दब के रह गई। अच्छा, पानी के बाहर आकर प्रधन मुझे फिर एक बार धमकी दी कि अगर किसी को तुमने इसके बारे में बताया मैं तुम्हें जान से मार दूंगा। उसके बाद हम दोनों करीब दिन के 2 बजे घर लौटे। इसके बाद में मुझे मार देने के डर से ये बात मैं किसी को नहीं बताया था। ये मेरा बयान है। तो दिस इज द स्टेटमेंट मिस्टर त्रिपाठी।
Yes.
So he has, of course, explained in the 161 CRPC statement as to why he remained silent on that particular day, on 10th and also on 11th, because the occurrence took place on 10th April. Around in the afternoon it took place, right? And because he was a small boy and was threatened by the appellant with dire consequence, that was the reason perhaps he did not disclose it before anyone. But police came to him on 12th
12.
and he gave the statement. Police came because in the first information report it is mentioned that
He
had
along with that,
accompanied the appellant and the deceased to the jungle for bird hunting purpose. So, however, the one thing that the very informant who just few minutes ago has not stated anything when the inquest was held, there was no suspicion on any. on the appellant is lodging the FIR that they went together and this is how uh, the child went with them and occurrence has taken place and is suspecting so and so. So what changed his mind within these few minutes? You see, the timing of the inquest is
1 p.
1
1 p.m. to 1
one inquest କାରଣ ଯୋଉଟା ବାହାର କରିଥିଲା inquest time ହଉଛି 12/4/2004 ଦିନ ଉପରେ ଲେଖା ହେଇଛି ଦିନ 1ଟାରୁ 1:40 ଭିତରେ ଇନ୍ସପେକ୍ସନ ହେଇଛି ତ 1ରୁ 1:40 ପର୍ଯ୍ୟନ୍ତ in the presence of the informant and other witnesses the inquest was held. All the details have been filled up. There is no allegation anywhere. Even there is a column circumstances if any which give rise to suspicion or foul play. ସେଠି ବି କିଛି ୟା ବିଷୟରେ ଲେଖା ହେଲାନି then opinion of the witnesses as to cause of death କିଛି ନାହିଁ then opinion of the police of course as to cause of death, that is para 10. So the relevant columns are column number 9 and column number 7. So if this was the state of affair at 1:40, what changed his mind and how he became so sure that the appellant was involved in the crime and because he accompanied if he had accompanied, he was all aware about the same appellant. So ଏଠି ଆଟଲିଷ୍ଟ ଲେଖା ହେଇପାରିଥାନ୍ତା ଯେ ସିଏ ତା ସାଙ୍ଗରେ ଜଙ୍ଗଲ ଯାଇଥିବାରୁ ମୁଁ ତାକୁ ସନ୍ଦେହ କରୁଛି
ସେଇଟା ନାହିଁ ସେଇଟା
ହଁ କାରଣ କଲମ ନଥାନ୍ତା କଲମ ସ୍ପେସିଫିକାଲି ଅଛି circumstances if any which give rise to suspicion of foul play. One column is there. The other column is their opinion of witnesses as to cause of death. And this informant is a signatory. And that has also been stated by the investigating officer that the informant was present. Because if the man did not return on 10th, even on 11th, then the matter could have been reported to the police. So if
Well,
there was
that
any kind of suspicion against the appellant, because they went
the
together.
IO said, Miller,
Yes.
that the complainant Vijay Bandra orally reported before me that his nephew Motak Purti had been towards Lili Nala on 10/4/2004 at 12 noon with his friends. He orally reported it to the IO.
Yeah. Who decoded
The first line.
Right.
There he has stated उसका जीव जब इंटरेस्ट प्रिपेयर्ड उनका जीव बाहर जो निकला हुआ था कमर और घुटने में प्लास्टिक लिपटी तार द्वारा 2 पत्थर बंधा हुआ था सिर का पीछे चोट था गला में फुलवा आया था ये सब कुछ देख के वह मुझे
पूरी तरह
महसूस हुआ रहा कि कोई मेरा भांजा को मर्डर किया गया हत्यारी मेरे भांजा के मर्डर के करके उनको कमर और घुटना में पत्थर बांध के लाश को छुपाने के लिए नाल का पानी में डाल दिया मैं इस हत्याकांड में because of that seeing this he suspected
That this
whom he saw along with his nephew.
No, the timing is very important. You inquest report.
से कोई आईओ कोई बोले The FIR was lodged around 1:45 or
Eight
2
पर
PM.
लिखा है जी, FIR is the timing of the FIR. Normal FIR. Okay. It was the date of occurrence is
2 PM.
2 PM. Information received होगी 12 ରୁ 2:15
2:15
spot रे और 3:15 थाना 3:15
So he had been to the spot
right.
when the inquest report was prepared.
No, question is that ତମେ ଗୋଟେ ଲୋକଟାକୁ ଟୋଟାଲ 1:40 ପର୍ଯ୍ୟନ୍ତ କିଛି ସନ୍ଦେହ କରୁନ।
ସେଠି ଦେଖିଲା ସେ inquest report ବେଳେ ଦେଖିଲା ଦେଖିକିରି ତାପରେ he lodged the FIR.
ଯଦି ସେତେବେଳେ ସନ୍ଦେହ ହଉଥାନ୍ତା ତାହେଲେ ତ ଏଠି ଲେଖା ହେଇଥାନ୍ତା ଆକୁ ଆମେ ସନ୍ଦେହ କରୁଛୁ କାରଣ ସେ ଯାଇଥିଲା। ତ ଏଠି କିଛି ନାହିଁ ଟୋଟାଲ 1:40 ପର୍ଯ୍ୟନ୍ତ କିଛି ନାହିଁ। ତ ଏଇ ଯୋଉ ତା ଭିତରେ 1:40 ରୁ 2:15 ଭିତରେ ହଠାତ୍ ତାର କଣ ଚେଞ୍ଜ ହେଲା ନା ଏଇ ଯୋଉଟା ଆପଣ କହୁଛନ୍ତି ଯୋଉ ଆକ୍ୟୁଜ୍ଡ
Yes, my lord.
ସେଟା
First IOR statement.
ଆଇଓର ଷ୍ଟେଟମେଣ୍ଟ କୋଉ ଲାଇନଟା କହିଲେ?
ଏଟା ହଉଛି second line, third line.
Page.
Vijay Bandra.
Page.
First line.
ଆଚ୍ଛା ଏଇ
First or third line.
Vijay
Bandra orally.
Bandra is the informant.
Yes. Orally reported before me that his nephew Motak Purti had been.
That is on 12/4/2004.
On 10 at 12. এটা লেখা নেই।
আচ্ছা on 10/4 ନାଇଁ এটা यूडी केस ହେଇଛି 12 ତାରିଖ ଦିନ।
Yes, on 12/4/2004.
At about 12 noon with his friend the accused and one boy namely Gardi Sayan for bird shooting, but his nephew had not returned. When the informant inquired from the accused about the nephew, so he gave out that he had left so and so at Godupada. So they searched for the nephew but could not find him. On so and so, they came to know that the dead body was floating in the water. And when he went there, identified the dead body. So he suspected that the accused might have been killed. The oral report so and so was reduced to writing. So that means the UD case was also instituted on 12th, right? But that particular report, what he has stated in that report, that was not seized. Perhaps that was the question put in the cross-examination, that why you have not ସେଇଦିନ 12 ତାରିଖ କହୁଛି ପରା
On 12/4/2004, I was in my present post. On that day, while inquiring into the UD case,
କାରଣ ସେଇ ଯୋଉ inquest report ରେ come to the inquest report, ଏଇ ଯୋଉ inquest report ଦେଖନ୍ତୁ ଦେଖା Belpahar PS UD case number 1 of dated 12/4/2004. 12 ତାରିଖରେ UD case registered ହେଇଛି, right? 12 ତାରିଖରେ ତାପରେ inquest ମଧ୍ୟ UD case ରେ ହେଲା, ସେ ପର୍ଯ୍ୟନ୍ତ FIR ଆସିଲା, ତାପରେ FIR ଆସିଲା। FIR ଟା ଆସିଲା 2ଟା କେତେବେଳେ, ମାନେ 20-25 ମିନିଟ୍ ପରେ FIR ଲାଗିଛି। So ଏଇ ଯୋଉଟା statement କହୁଛି ଯେ 12 ତାରିଖ ଦିନ I was in my present post on that day while inquiring into the UD case. The complainant orally reported before me.
That is nephew.
That is nephew as one so on that day while inquiring into the UD case means UD case was instituted perhaps prior to that.
Yes.
During that UD case inquiry, this man reported, for which
UD case was registered at 11 AM.
UD case was at the instance of PW2.
Yes.
Not at the instance of the informant.
Yes.
Because you come to that PW2's evidence, PW2 says that I had been to page number 28.
Yes, ma'am.
I had been to attend call of nature. I saw the dead body floating, right?
Yes.
Then I could not
identify this dead body.
I could not identify the dead body. I came and reported at Bandabal outpost orally. Bandabal outpost had informed Belpahad. Useless dialogue. Inquiry. The dead body was taken out of water. The man was wearing so and so stone. So inquest was held. So this was the report. That means in the UD case report, there would be nothing against the appellant.
No.
Because he had come to attend call of nature.
Bas.
Saw the dead body.
And informed the police.
Then he went to the
Outpost. Sorry.
Outpost wala janaile Belpad Thana. Then this UD case was instituted. So obviously UD case report, in the UD case report, there would be nothing against the appellant. Right. Now, however, when question is that when the dead body was brought from the water and it was identified by none else than the informant who has not, of course, been examined, to be that of the deceased, his nephew.
So PW2 is also saying one man came and identified the dead body. So
One man, informant. One man came and identified. So then the inquest was held.
Yes.
And that is the reason why the informant has signed also the inquest report. So again, the question comes that
this fellow has also signed in the inquest. This PW2.
So inquest report PW2 na kono? Prafulla Kumar. Inquest report avarko. Hey, Prafulla Kumar. Prafulla Kumar rai eta hoji informant signature. Hala. So again, question that जदि किसी गोटे 40 रे किसी संदेह होउनथला केही किसी नाही से आसी प्रेजेंट करूची ताहले एतलाटी केमती देइदला से ये वर्तमान एतलाकारी भी तो एग्जामिन. So now the entire case rests virtually whether we accept the evidence of
PW4
or not.
And then came to Miller extrajudicial confession.
Extrajudicial confession. Let us see that extrajudicial confession.
PW6
also turns hostile, my lord.
Maybe
hostile.
I can.
Please read.
Right.
Page 37.
I know the accused. I do not know the deceased. The accused is my co-villager. I also know Vijay Bodra, who resides in front of my house. The nephew of Vijay was also staying with him. The nephew of Vijay was murdered. Thereafter, the accused remained absconded. I accompanied Belpahar police to Tata in search of the accused, but could not find him. Thereafter, I went to my village where I found the accused. In the village, the accused disclosed to me that he had committed murder of the nephew of Vijay Bodra. Then after the turns hostile, leading, it is...
No, this line he has stated about the... In the village, the accused disclosed...
No witness has deposed as to the reason as to why the accused committed
no one.
No. Motive is not there.
From the FR and from the statement of the PW4, it is stated that there is a cordial relationship, that they are friends.
It's a CPC would accuse. କିଛି ଜାଣିନି ସେ କାହିଁକି ବସିକି ଜାଣିଛି କିଛି ଅସୁବିଧା ନାହିଁ ଇଜ unable to do it ଦେଖୁନ ସେ କିଛି କରିନି ଆପଣଙ୍କ ନମ୍ବର ସେଟା ସବୁଗୁଡା ସିଲେକ୍ଟ ହେଇଯାଇଛି କହୁନ କଣ ପ୍ରୋବ୍ଲେମ ହଉଛି अंडरलाइन कला पूरा एंटायरटा पड़ जाଉଛି ଏଇଟା ଆପଣ ଯାହା କରିବେ ସେଟା underline ହବ ତ you did not do anything no no ସେଠି ନାଇଁ ନାଇଁ ମୁଁ କଲେ ହେଇଯିବ ଯେ କିନ୍ତୁ ବଟ୍ ତା ଦେହରେ ସେ ଯୋଉ ମାଉସ କାହିଁକି ଅପରେଟ୍ କରୁଛି ସେଟା କଲେ ସିଲେକ୍ଟ ହେଇଯିବା କଥା ଅଟୋମେଟିକ ତମେ କଣ କରୁଛ ନାଇଁ ଆପଣ କଲେ ଖାଲି ଗୋଟେ କଲେ ସେ କିଛି ମାଉସ ଧରୁନି ଅଟୋମେଟିକ ହବା କଥା ହାଇଲାଇଟ୍ ତ ନାଇଁ ରହିବ ସେ କିଛି କରିନି ନାଇଁ ସେ ପୁରା that is the problem which
had stated to him that after killing the accused, he tied the dead body with the stone and threw it into the nala. It is not a fact that I am deposing falsely and process. I am working in the company since 2003. I left for the village during March and returned in the month of May. I cannot say when I heard from whom the death of the deceased. I cannot say how many nephews of Vijay Bodndra. I know that the nephew of Vijay Bodndra was killed. I was told by the police about the case. I visited Tata and Ramtandi and then Chaibasa. I was paid by the company to go to my village and Chaibasa, but the expenses were borne by the police when I visited Tata. We found the accused at Tata on the third occasion. I cannot say the date, day, and month when we found the accused. The accused was found at Uditpur. I cannot say the particular area of Uditpur where the accused was found. I cannot say the type of dress the accused had put on that day, that time. The accused confessed before me at Ramtandi when I had visited from second time. I disclosed it to Belpahar police. When the accused told me about this in village, I did not disclose it to any villager. It is not a fact that I did not find accused in the village, that I am deposing falsely that the accused had confessed before me in order to falsely implicate him in this case.
You see this witness statement
Right.
that the accused was found at Uditpur.
Right.
And at that place there was no disclosure.
No.
No.
Second time the accused was found at Ramthandi. There this disclosure has been made. Then third time he says that the accused was found at Tata on the third occasion. This man is just a co-villager.
Right.
Co-villager and he's a colleague
Mhm.
He's
working as a
working as
company.
a driver in RC.
And after that incident, the accused was not attending his duty.
Yes, madam.
Right.
Yeah, absconded.
Hmm. No, तार से closeness विषय से कोटी कौन कौची co-villager तो कोटे कहला आउ कौन आउ कोट पहले I'm working in the company
Company
since 2003. I
Where the-
left for the village during March. Returned in the month of March. I cannot say when I heard and from whom about the death of the deceased. I cannot say how many nephews so and so. I know that the nephew of so and so was killed. I was told by the police about the case. I visited Tata and Ramthandi uh, and then Chaibasa. I was paid by the company to go to my village and Chaibasa, but the expenses were borne by police when I visited Tata. We find accused at Tata on the third occasion. I cannot say the date so and so, so and so we found the accused. The accused was found at Uditpur. I cannot say the particular area of Uditpur where the accused was found. I cannot say the type of dress the accused was wearing. The accused confessed before me at Ramthandi when I had visited for the second time. There is nothing about the closeness that
yes, that
is
is
just a
Right.
co-villager. Now the next one is that leading to discovery of that plastic rope that only IO has stated about it.
yes, yes. Only I.
So what he has stated that which line of the
My lord, page 41, para 4.
yes, read out that.
My lord, in course of investigation, I searched for the accused and also the boy who had accompanied them in the forest towards Lillari Nada. In course of search for the accused, I also searched his house situated at a slum area behind the CWS office and recovered 24 feet of red color electric wire and prepared seizure list exhibit 9 in presence of witness Rajendra Rai and Manoj Jaipuria.
No, where is that are the instance of the accused?
No, my lord.
Mr.
No, that
So that is not the
No, my lord.
so
No
that
reading.
that was not recovered at the instance of the
instant of
No, my
Course of search of
that
search,
was
he had been to his
My
house.
lord.
Where
My-
he sees that
no
recovered
reading to
that for
discover.
24 feet red
and
color.
recovered so and so electric and prepared the seizure list in course of search of the accused. So from the house this was
So,
red
as,
color electric wire was
my
seized.
lord, as it was stated in the 161, there is a new house.
Please come to this side.
deceased.
Hmm?
My lord, in page number 43,
Hmm.
IO stated, I have not mentioned in Exhibit 2 in the inquest report in column 7 about the color of the electric wire using in drowning the deceased.
No, if
Yeah.
suppose similar wire was found
Hmm.
at in the body which was used, then matter is different. But there is no such evidence. So mere recovery of some wares from the house of the accused, it cannot be said to be an incriminating circumstances.
So is there any evidence on record that the wire, electric wire used for tying the dead body
That
was same as the wire
No,
which
that
were
is there
recovered
is
That
No,
is
from
not
no,
there.
that is not
That
there.
is not
No.
there is no such evidence. So one is Mr. Tripathi,
Yes,
one is eyewitness,
yes,
second is extrajudicial confession,
yes.
then the third is that absconding part.
Absconding part
Ab-
and the doctor's evidence.
Doctor's evidence. We'll go to the doctor, but this absconding part
Yes.
evidence is stated by PW7, the IO. In paragraph number 5, he has stated that when I visited the employer of the accused and verified the attendance register for the month of April 2004 and seized the register, it was found that the accused was absent from his duty with effect from 8/4/2004 and not resumed till the date of the verification, that is 27/2000. So for more than 3 months he was
Yes.
not attending his work, and accordingly the that particular register, attendance register, was seized as under seizure list exhibit 5.
Yes.
And that was given in the Jima of one Sribacha Kumar Sahu, so and so. So whether that attendance register was produced in court, whether anybody from that company was examined,
My
so let us come to exhibit 5. Exhibit 5 was. ଆମର ଯୋଉ exhibit 5 ରେ ଯୋଉ ସିଜିଅର ଲିଷ୍ଟ ରେ ଖାଲି ମେନସନ ହେଇଛି 11ଟା ହଉଛି circumstance of seizure, ହେଲା ଲେଖା ହେଇଛି ଆଜି 20/7/2004 ତାରିଖ ଦିନ ଉପରୋକ୍ତ ମୋକଦ୍ଦମା ତଦନ୍ତ କରିବା ସମୟରେ RCP ସୋଆଣ୍ଡସୋ ଇନଚାର୍ଜ ଭରତ ସିଂ ଏପ୍ରିଲ ମାସର ଉପସ୍ଥାନ ଖାତା ଯେଉଁଥିରେ ମୁଦାଲା ସୋଆଣ୍ଡସୋଙ୍କ ନାମ ଲେଖା ଥାଇ ତାର ଉପସ୍ଥାନ ଥାଇ ଆଣି ଦାଖଲ କରିବାରେ ତାହା ନିମ୍ନଲିଖିତ ସାକ୍ଷୀମାନଙ୍କ ସାମ୍ନାରେ ଜପ୍ତି କରାଗଲା ଏବଂ ଜପ୍ତି ତାଲିକାରେ ସାକ୍ଷୀମାନେ ଦସ୍ତଖତ କଲେ। and 13ଟା ହଉଛି description of the properties attendance register of so and so। ବର୍ତ୍ତମାନ ଏଥିରୁ ଏଇ ଯୋଉ ସିଜିଅର ଲିଷ୍ଟରୁ କଣଟା ଜଣା ପଡୁଛି, ଗୋଟେ ଆଟେଣ୍ଡାନ୍ସ ରେଜିଷ୍ଟର ଜବତ ହେଇଛି। ତ ଆପଣ ଯଦି ସେ ଆଟେଣ୍ଡାନ୍ସ ରେଜିଷ୍ଟରକୁ ଟ୍ରାଏଲ ବେଳେ ପ୍ରଡ୍ୟୁସ ନ କରିବେ, ହେଲା, ତେଣୁ ସେଇ ପର୍ଟିକୁଲାର ପେଜଟା ଯଦି ମାର୍କ ନହେଲା, ତାହେଲେ ସେ ଆଟେଣ୍ଡାନ୍ସ ରେଜିଷ୍ଟରରେ ସେ କୋଉ ଦିନଠୁ କୋଉ ଦିନ ପର୍ଯ୍ୟନ୍ତ ତାର କାମ କରୁନଥିଲା କେମିତି ଜଣା ପଡିବ? ନା କୌଣସି ସାଥୀ ତାର କମ୍ପାନୀର ଯୋଉମାନେ ତାର ସହକର୍ମୀ ସେମାନଙ୍କୁ ଏକ୍ସାମିନ ଆପଣ କଲେନି, ଓରାଲ ଏଭିଡେନ୍ସ ନାହିଁ।
PW6 is there.
PW6,
Yes.
we'll go to that.
Mueller court.
He should have immediately informed the police that my is missing. Rather, after the dead body was recovered at the instance of somebody who had been to attend nature's hall, and UD case was registered, and he was called who identified the dead body. It's not that he immediately informed police that my nephew is missing. Informant of examine colony, that is another drawback. I am. He was this IO has been suggested during prosecution. It is not a fact that the deceased was having illicit relationship with his aunt, which might be the reason for the uncle to cause his death. That's Mr. Tripathi.
Yes.
गोटे ये होची भणजा
भणजा
तो भणजा शिकार करिया को जंगल को जाइछि चढ़ई शिकार करिया को ये लोकटा जानिछि इन्फॉर्मेंट जे मुदाला जाइछि एवं गोटे छोट छुआ जे होची PW4 एमाने सांग होइकिन जाइछन सीए से दिन फेरिले नाही तो ये तो निजे आगे सर्च करिवा कथा लोकालिटी रे कोड गल
से तक पचार
का को पचारछि
से अपेलेंट को पचार से कुछ ताको हम आ गोटे को जगह छाड़ दे के आइलु ना से जाइछि आ गोटे को जगह छाड़ दे के आछि बोली कहल
नहीं सेटा तो आपन को एफआईआर स्टोरी एफआईआर आपन तो साक्षी आनी नांती ना आपन एग्जामिन करना दी एंड वर्तमान एविडेंस कोन रहिला अच्छा किछि नहले से पिला पाखु जीवा कथा सी जे जाईथिला जो छुआटा जाईथिला PW4 फिर तुम तो जाईथिलो सांग होई किनी ये कुआडे गला तो PW4 किछि कहूनी पे जे मो पाखु केई आसी किनी पचारि चंदी तेनु if the no inquiry was made from PW4 was available, very much available. So that is another feature to show that perhaps this informant was not aware that PW4 had accompanied the deceased and the appellant to the jungle. आमे तीनी जण जाइछंती मो भणजा जाइछि accused जाइछि आ गोटे छुआटे जाइछि से गाँर से माने जाइछंती जंगल को चढ़ई शिकार करिया पई तो तीन जण ए भणजा फेरिलानी तो जदि मु खोजिबली तो दी जण को पाकु पचारिबी जे तम संगे तो मु भणजा जाइतला कुआडे गला
बड़ लोक पचारला से कहले ताकू छाड़ दे के आछू आ छोटो छुआटा पई पचारि
टर्न टू पेज
15 यस मैम
इसलिए मैं प्रधान को मेरा भांजा का बारे में पूछे तो वो बोलने लगा कि मोटा को वो घोड़ा पड़ा में छोड़ दिया
यस
पर मेरा भांजा रात को घर नहीं लौटा इसलिए इधर उधर ढूंढ रहे थे आज सुबह कल तक 2-3 दिन खोजिला तापर he didn't report the matter to the police no आरो छुआटा को पचारला आरो छुआ we are concerned with that the other boy
ताकू पचार
ना दी परा बर्तमान इन्फॉर्मेंट आपनकर एठी एग्जामिन हेई
हेला ड्रॉबैक
आपनकर रीजन जो जोउछंदी ये रीजन किए देला जजमेंट रे जो रीजन दोजन कोड पाइले से
जजमेंट रे अछि सेटा
नहीं पाइले ना कोई एविडेंस ना कोन ट्रायल कोर्ट जाइथिला कि रीजन वाज प्रेजेंट एट द स्पॉट और ही वाज रीडिंग द माइंड ऑफ द इन्फॉर्मेंट व्हाट इज द रीजन हैज बीन असाइन्ड फॉर नॉन एग्जामिनेशन ऑफ द or what the prosecution why such a vital witness who is the informant and who has stated about the last scene and is not examined. What is the reason? Which paragraph you are placing?
Page 6, paragraph 6.
Page 6, paragraph
6.
Okay, read out again once again.
The prosecution has examined 7 witnesses. The informant, the uncle of the deceased, and his aunt are not available to be examined and their whereabouts are not known. It is reported that they had left Jhumpri-Pada slum area. The prosecution therefore declined to examine them. The informant has only lodged a report at the spot when the dead body was recovered by the police from Lillari Noda. The affair lodged by the informant is only relevant for the purpose of that his nephew had accompanied the accused and a 10-year-old boy, Gardi Sayan, towards the jungle for bird shooting, and he saw the accused and that boy returning back in the evening without his nephew. Even though the informant has not been examined, it is to be seen whether this part of story is proved by the prosecution through the only eyewitness, Gurdi Sayan, a 10-year-old boy.
So that means, as it appears from this particular paragraph, perhaps summons were issued to the informant, but
written on
they,
top.
कौन ହେଇଛି order sheet देखी ट्रायल कोर्ट रो आपण चार्ज केबे फ्रेम होला देखले
20.
देखियो कौन अछि what is the date of framing of the charge during the lunch
21/2/2005
okay we are concerned with
Okay.
informant ना हला कोन
प्रधान विजय बांद्रा.
विजय
बांद्रा.
बांद्रा
yes
बोंद्रा.
Summons issued against so and so as the witnesses are left. So reported by the Havildar so and so. जो दिन तारीख रे डिक्लाइन ହେଇଛି informant को that is on 17/1/2006 17/1/2006 रे relevant part होची The summons issued against charge sheet witness number 1 and 3 are returned without service. Are the witnesses left the place as reported by the Havildar A. Kerketa. PP declined the rest of the witnesses, that is CS number 1 and 3. So ଏତିକି କେବଳ ଲେଖା ହେଇଛି, ବୁଝିଲେ ନା? ଯେ ସମନଟା ଗଲା, ସମନଟା ଫେରି ଆସିଲା ଯେ ଏଇ ଯୋଉ ଆଡ୍ରେସ ରେ ସେମାନେ ରହୁନାହାନ୍ତି। And PP declined. Now come to that again once, and what is that observation which has been made now? Read out once again, paragraph number 6.
The prosecution has examined 7 witnesses. The informant, the uncle of the deceased, and his aunt are not available to be examined, and their whereabouts are not known. It is reported that they had left Jhumpuripada slum area. The prosecution therefore declined to examine them. The informant has only lodged a report at the spot when the dead body was recovered by the police from Lillari Nora. The affair lodged by the informant is only relevant for the purpose that his nephew had accompanied the accused and a 10-year-old boy, Gordi Sayan, towards the jungle for bird shooting. And he saw the accused and that boy returning back in the evening without his nephew. Even though the informant has not been...
That's all right.
Right.
So that means summons ଯାଇଛି, ହାବିଲଦାର ନେଇକିନି ଗଲା, ଦେଖିଲା ଯୋଉ ଆଡ୍ରେସ ରେ ଅଛି ସେ ଆଡ୍ରେସ ରେ ମାନେ ରହୁନାହାନ୍ତି, ତ ଆସିକିନି ରିପୋର୍ଟ କରିଦେଲା, ଇଏ ତାକୁ ଡିକ୍ଲାଇନ କରିଦେଲା। ତ ସିନସିୟର ଷ୍ଟେପ୍ has not been taken that ଏମାନେ ଏଠି ରହୁନାହାନ୍ତି, ରହୁଛନ୍ତି, ତେଣୁ ଏ whereabouts not known ବୋଲି ଯୋଉ ଅବଜରଭେସନ ଟା କରିଛି, that is not correct. ସେ ଖାଲି ଲେଖିଛନ୍ତି ଏଇ ଯୋଉ ବର୍ତ୍ତମାନ ସେମାନେ ସେଠି ରହୁନାହାନ୍ତି, ତେଣୁ ପ୍ରସିକ୍ୟୁସନ କୁ ଅପରଚ୍ୟୁନିଟି ଦବାର ଥିଲା ସେଠି କୋର୍ଟର ଯେ ଏମାନେ କୋଉଠି ରହୁଛନ୍ତି ତମେ ଦିଅ ଇଏ, ସେମାନେ ପ୍ରସିକ୍ୟୁସନ ତାର ଏଜେନ୍ସି ଲଗେଇକିନି ଦେଖିଥାନ୍ତା ତାର ରିଲେସନ ହଉ ବା କୌଣସି ଜରିଆରେ ଯେ ନାଇଁ ତାର whereabouts not known, ଆମେ ତାପରେ it's a matter would have been different. So one thing about the silence of PW4, the other thing is that the conduct informant disadvantage कौन ही होची ना जो suspicions गुड़ाक create होची से गुड़ाक जेहेतु माने ये ही पारलानी सेटा को डिबार ही जाउची ताको वर्तमान जदि informant मन करो तो examine ही था ताको पचारी पार था डिफेंस काउंसिल ना जे तमे जदि 10 तारीख दिन तुमको ये इनफॉरमेशन टा देला से हमको जगह को जाईची तमे भाबुतिलो सेही दिन से फेरियो बेली, तो जेतेबेले फेरिलानी तमे पुलिस पाखो को रिपोर्ट देइथिलो से कहता ना नाइ देनी कोन पई देलनी हला, तमे से जो छुआ संगे जो जाईथिला बेली देखुचो को से छुआ घर को जाईथिलो, तो ई सब जिंस तक पचारी पारथांते, but that would be a factor de nahi actually यार किछि एमती नॉलेज नाही बा ताकू अक्यूज एमती किछि इंफॉर्मेशन देइनी बा ए छुआ ता संगे जाइनी, एगुडा माइट बी दैट आफ्टरवर्ड्स क्रिएटेड, कारण गोटे 45 पर्यंत 12 तारीख जेतेबेले इनक्वेस्ट हेची 12 ना केबे उठा 12 तारीख गोटे 45 पर्यंत से टोटल किछि नाही तार ब्लैंक कहा बिकु संदेह करनी, तो हठात 20-25 मिनिट पर से केमती गोटे एतला टाणी दे दूची जो एतलाटा कि से दिन दिया हेची कि केबे दिया हेची दैट इज डाउटफुल, कारण एतला दिया हेची आपनकर डेट ऑफ एफआईआर होची केबे एफआईआर टा बाहर करो, you see the date of FIR is 12/4/2004 and right, yes, so the SDGM signature is 15/4/2004,
Yes.
So if it was lost on 12/4/2004 and dispatched from the police station on 12/4/2004, why it reached before the SDGM on 15/4/2004? So you are to give clarification. They हाँ नहीं हम FIR पठेई थुलु कोर्ट रे पुलिस कोर्ट रे पहुंची गला हला से मैटर टा SDGM को पाखरे प्लेस करिया को डेरी ही गला हाँ FIR टा जेमती जाए प्रत्येक दिन जेते को FIR आसे से मैटर प्लेस हुए SDGM को पाखକୁ बा जे कॉग्निजेंस टेकिंग मैजिस्ट्रेट थी बतांग पर से मान उडे सिग्नेचर करंती टाइम टू टाइम जो डॉक्यूमेंट्स मध्य आसे ड्यूरिंग कोर्स ऑफ इन्वेस्टिगेशन ता देरे मध्य नोटिंग करंती तेणु जदि एतलाटा 12 तारिख दिन हेइची 12 तारिख दिन आपण कहउछन्ती थाना रु पठेई देले बेली हैला ताहाले आपणकर 12 रे न पहुंचू मैजिस्ट्रेट को बाहर 13 ते पहुंचीवा कथा 13 नाही 14 नाही आपणकर 15 तारिख रे कोर्ट तेणु दैट आ गोटे कथा होची जदि आपणकर
Apart from that, PW4 in his cross-examination, para 3 stated, I am disclosing this fact
First
for the
time.
first time today. I did not disclose to anyone as the accused had threatened me. I was examined, again says I was examined by the police. Didn't say that I have stated so once before the police before deposing in this court.
and another thing, Mr. This if you come to this postmortem report, this postmortem was conducted on 12/4/2004 at 2:30 p.m. Huh?
4:15.
4:15, right?
Admittedly, the deceased was carrying a gular.
Yes.
But the seizure list, none of the seizure list discloses that the gular is part and parcel of the seizure list. Gular should have been. Yes. The accused statement actually has stated that I don't know why
This case was.
has been initiated.
So what it appears that he was very sure that if I give threat to this PW4, he will never
remain
disclose.
silent.
He will remain silent because he is the star witness.
Yes.
So why, if you are not finding out any motive behind the commission
Yeah,
of
no
crime,
motive.
right? No motive. So no motive is forthcoming. So if, let us say, it is in his mind why he took the deceased and killed him. So if he had the intention or motive to kill why then he would took another boy just to depose against him afterwards to be an witness?
Yes.
मोर जदि आपण किछि मोटिव आनुनांती लेट अस से तार मोटिव तार मुंडरे थिला से कोन पई गोटे कोनोसी कारण पई जोटा कि प्रोसिक्यूशन को अगोचर सिए ता माइंड रे अछि मु आज याकू जंगल को नेकिन डाकिकिन नेबी चढ़ई शिकार बहाना रे ताकू मारिबी एया तो कथा आपण को राव ताल से छुआटा को से काई नबो
जो दिन अल्लाह तक छाड़ला कहीं तक भी तो मार देता.
हाँ माने नो ना वुड हैव बीन देयर टू डिपोज अगेंस्ट हिम छुआ उपरे खाली धमक दे देला बेली छुआ कॉन्फिडेंस एते ही गला जे छुआ
मु दौड़ी. He started running. So being threatened, he came back, stayed there, watched what he is doing. Then both of them took bath. So and they came. That is the story of PW4.
କାରଣ ଯଦି ଆପଣଙ୍କର ଏଫଆଇଆର ଷ୍ଟୋରି ଅନୁଯାୟୀ ଛୁଆଟା ଯଦି ଯାଇଥିବ ତାଙ୍କ ସାଙ୍ଗରେ ତାହେଲେ ଏ ଇନଫର୍ମାଣ୍ଟ ନିହାତି ଯେତେବେଳେ ସେ ସେଦିନ ଫେରିଲାନି ନିହାତି ସେ ଛୁଆ ପାଖକୁ ଯାଇକି ପଚାରିବାର ଥିଲା, ଦେଖିବାର ଥିଲା ଆଗେ ସେ ଛୁଆଟା ଫେରିଲାଣି କି ନାହିଁ। ହଁ, ଛୁଆକୁ ପଚାରିଥାନ୍ତା କି ଆକୁ ପଚାରିଥାନ୍ତା ଇଏ କାହିଁ ଫେରିଲାନି। ସୋ ଏଗୁଡାକ ହଉଛି ଜଣଙ୍କର ନର୍ମାଲ କୋର୍ସ ଅଫ କଣ୍ଡକ୍ଟ ଏଇଟା ହବାର ଥିବ।
ଇନସିଡେଣ୍ଟ ପରେ ଗାଁ ଛାଡିକି ପଳେଇଲା
ତେଣୁ
ତା ସ୍ତ୍ରୀକି ଧରି।
we will take up this matter tomorrow
Yes,
because the time is there. So you have heard the discussion. So accordingly, prepare the case tomorrow and see that how whether these circumstances can be believable or not.
Right.
One is we have stated that suppose delay of receipt of the FIR in court, what would be its effect? Prosecution says that the FIR was lost on 12th. It reaches the court on 15th, 3 days thereafter. So whether from that it can be inferred that it was lost on that particular day or it was lost afterwards, but it has been antedated. There are some decisions. Find out it.
Right.
Okay. Delay of receipt of the FIR in court, one aspect. Number two, the conduct of the witness. He is not disclosing before anyone. The ground is that he was threatened.
Right.
But again, police comes, he discloses. That witness has not been asked by the informant, okay, whom he has seen to have accompanied the appellant and the deceased. So that is another feature which might be creating. Then the extrajudicial confession part, there you may find that it must be before such a person on whom the accused can repose confidence. ମୁଁ ଯଦି କାହା ଉପରେ କ୍ଲୋଜନେସ୍ ନାହିଁ, ମୋର ଯଦି ତା ଉପରେ ଭରସା ନାହିଁ, ତାଠୁ କିଛି ମୋର ସାହାଯ୍ୟ ପାଇବାର ନାହିଁ, ହେଲା, ମୁଁ ତା ପାଖରେ ଯାଇ କାହିଁ ମୁଁ ଦୋଷ ସ୍ୱୀକାର କରିବି। ଓକେ, ସୋ ତେଣୁ extrajudicial confession which is admissible under section 24 of the Evidence Act, it says that it must be voluntary and it is to be also taken into account before whom it was made. ଜଣେ ଯାଇକିନି ଜଙ୍ଗଲରେ ଅଫେନ୍ସଟା କରିକିନି ଚୁପଚାପ ରହିଯାଇଛି, ଆଉ ଗୋଟେ ଛୁଆ ଯଦି ଯାଇଥିବ ତାକୁ ଧମକେଇ ଦେଇଛି କାହାକୁ କହିବୁନି, ତ ସେଇ ଲୋକଟା ଏତେ ଯଦି କାମ କରିଛି ତାହେଲେ ସିଏ ଯାଇକିନି କାହିଁକି ଗୋଟେ କୋ ଭିଲେଜର ଯାହା ସାଙ୍ଗରେ ତାର କିଛି କ୍ଲୋଜନେସ୍ ନାହିଁ, ତାଠୁ କିଛି ସାହାଯ୍ୟ ପାଇବାର ନାହିଁ, ତାକୁ କାହିଁକି କହିବ? ଯାଠୁ ରିପେଣ୍ଡ କରୁଥିବ ଅଲଗା କଥା, କ୍ଲୋଜନେସ୍ ଥିବ, ଭାଇ ମୁଁ ଏମିତି ଭୁଲ କରିଦେଲି, ତାକୁ ଇଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର, ତାକୁ କାହିଁକି କହିବ? ତ ଏଇ ଟାଇପର ଯଦି ଏଭିଡେନ୍ସ ଆସିବ ତାହେଲେ ହାଉ that extrajudicial confession is to be dealt with by the court. You may find decision that in such circumstances when there is no evidence about any closeness, any kind of that why the person would repose confidence, why what benefit would get by disclosing this confession before that person, then it is very difficult to accept. Okay. Then the
absconding part.
Absconding part is only the evidence of the IO.
No, PW6 is there.
Acha, what PW? Let us see that. You are telling we forgot just. Hey, and PW6 relevant. Yes, who is he? PW6.
The extra witness from the extrajudicial.
For whom he made
Extrajudicial confession before me.
No, PW4 has been declared hostile.
PW6.
PW6, huh?
Right.
PW6 has been declared hostile.
Yes.
Se koudi kouchi je.
Mularu.
Padile?
I know the accused. I do not know the deceased. The accused is my co-villager. I also know the Vijay Pudra who reside in front of my house. The nephew of Vijay was also staying with him. the nephew of Vijay was murdered. Thereafter, the accused remained absconded.
That's all only. See type of evidence to be.
And he accompanied the police to Tata in
Yes.
search of the accused, but could not find him. In the cross-examination, I think he has stated that he.
No, he said that on second time when he extrajudicial confession was made before that PW6 na.
Yes, ma'am.
PW6 टा आपण देखंतु PW6 टा जाइथला का संगरे
Police संगे
पुलिस संगरे जाइथला तेणु जदि भी एक्स्ट्रा जुडिशियल कन्फेशन हेतिवो पुलिस प्रेजेंस रहिथि ता कहलानी कि पुलिस पैसा खर्च कले एवं मते नै कि जाइथिले
Expenses were borne by the police. Expenses
were borne by the police.
We found the accused Tata on the third occasion.
थर्ड दिन पुलिस संगे जाइथि पर expenses were borne.
Like that.
गोटे लाइन नाही expenses were borne.
तेणु was paid by the company so and so.
हाँ तेणु पुलिस संगे जाइथिला पुलिस संगे देखाला पुलिस प्रेजेंस रे एक्स्ट्रा जुडिशियल कन्फेशन हेछि.
But the expenses were borne by the police when I visited Tata.
Now what do you want to say? You just search it out.
Right.
The best evidence would have been that attendance register. जो कंपनी से काम करूथला से कंपनी रु घटना परठू
I was told by the police about the case.
हाँ so घटना परठू से 3 मास रु ऊपर से कंपनी अटेंड करू नथला एटा होची सेइत पई प्रोसिक्यूशन आनी चंदी से एविडेंस ता. So the best evidence would have been the attendance register. So attendance register was seized, but that attendance register was not produced. Right.
One employer also examined, but he not stated anything. Employer पे examined he. PW4.
PW4
pardon. PW5.
PW5 is the employer.
What he has stated?
On 27/2004 at about 10 a.m., police seized the attendance register of RCP Juravaga in respect of the same year. The name of the accused also appear in the register. Seizure list was prepared in my presence and I signed thereon. Exhibit 5 is the seizure list. 5/1 is my signature. 5/2 is the signature of the Ajay Kumar Mahato. Cross-examination. It was the register of the month of April. I cannot say how many persons were required to sign in the attendance. I cannot say at what serial number of the accused appears in the attendance register. I am not acquainted with the signature of all the employees working in the company. I have no knowledge for what register was seized. It is not a fact that no such register was seized. I signed thereon at instance of police.
There is nothing because register टा प्रमाण हेइथले हाँ तेणु आपणकर को केस होची एप्रिल रु मे पर्यंत ए जो रजिस्टर कथाटा भी कहउछन एटा होची केवल एप्रिल तेणु मे जुलाई रे मध्य प्रमाण करिया उथिला जे अक्यूज्ड एब्सेंट थिला सेटा आपण प्रमाण करिना तेणु खाली रजिस्टर टे गोटे देखै देले रजिस्टर टे सीजर लिस्ट हेइथला तेणु एटा इन्फरेंस हबो जे रजिस्टर जदि सीज हला एवं आपण ताकू विथहेल्ड करनेले जिम्मारे देले पब्लिक प्रोसिक्यूटर फाइल करथांदा पिटिशन जे जिम्मारे नै थांदा ताकू आनी प्रोड्यूस करो बोली समन्स रे लिखा हिथांदा आनी प्रोड्यूस करो मालिक आछि मालिक जरिया रे प्रमाण हिथांदा तो सेईटा को आपण जदि प्रमाण न करिवे रादर एटा प्रिजम्पशन हबो 114 ने जदि से डॉक्यूमेंट टा प्रोड्यूस हेइतांदा जदि से रजिस्टर टा प्रोड्यूस हेइतांदा बोध हुए सेटा आपण को एगेंस्ट रे जाइतांदा प्रोसिक्यूशन एगेंस्ट रे सेही पई आपण ता विथहेल्ड कर रखले 114 रो देयर इज ए देखिए एविडेंस सेक्टर को it deals with court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts in particular case. Now you just come to ये जी देखंतु आछि the court may presume G को आसंतु the evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. ହେଲା जदि एटा प्रोड्यूस होइथांदा एवं सेटा को विथहेल्ड कर दिया गला ताले प्रिजम्पशन हबो जे जे ताको विथहेल्ड करची बोधवे सेटा प्रोड्यूस हेइतले सेटा ता विरुद्ध रे जाइथांदा सेइत पई से ताको विथहेल्ड कला ହେଲା तेणु ए जो रेजिस्टर रो register for month of April only produced, right? Not May, June, and July,
Till the date of arrest.
right? And register was attendance was not registered. This PW5 would have been the best person to prove that because he is the owner of that company.
It has also not been proved that in the month of April, on which date he remained absent from duty.
Register the प्रमाणिक लेवल. So accordingly, you prepare your case. We'll take up this matter tomorrow.
Right.
एटाकू ये मारी किनी रखो सेठी. We'll continue this matter.
Yes, no.
Right.
Yeah. Yes, yes. Hmm. Hmm. Yeah. Give it, give it. Please. Give it, give it.
Supplementary list item number 1.
Hmm.
Along with list of citations, along with the citations. We are exchanging the written notes also, right?
This is the written note filed by the petitioner, no?
Yes.
Miss, have you got a copy of it? Please. How have you dealt with? Just tell me in a nutshell that the issues have been dealt with.
Yes, my lords.
Your Lordship, में
Issue number 1, page 8.
Okay, that is issue number 1, 2, and 3.
2 and 3. Then
It continues up to
page 12, my lord.
Okay.
Then issue number 4 to 40.
Just a all right, just a minute. So issue number
4 to 14.
no one. This is first one is 1, 2, and 3.
3, my lord.
That is page number
8,
802 12.
12.
Okay. Then you said it is 13, na?
No, at page 12, my lord.
12.
Para 8,
That is issue number
4 to 14.
4 to 14.
40214.
14, my lord.
That starts at page 12.
Page 12, my lord. Para 8.
It goes up to
page 64, my lord. Up to para 21.
right. Then
issue number 15, 16, 19, and 20.
15, 16,
19 and 20.
19, and 20. It
From
starts
para
at page
22. Para page 64, para 22.
right. It continues up to
Up to page 105, my lord. Then, my lord, issue number 17 and 21.
that starts at page 105.
105, para 41.
Right. It continues up
to, my lord. Page 194.
right. Then
Issue number 22, 23, 24, 25, 26, and 27. 22 to 27.
22 to 27.
Yes, my lord. At page 194, para 73 to
Yes.
page 209.
28 to 32, right?
28 to 32. Page 209, para 81.
It continues up to
Up to page 238, my lord.
239.
238.
not 238 sorry, sure.
Again.
Page 238, right?
Then issue number
18,
page 239.
starts that,
Page 239.
issue number
18,
yeah.
33 to 37.
33 to 37. It starts at page 2.
It's only one page, 239.
Only one page. Okay.
One page. Sorry.
Then
37 and 38 at page 240.
37
and 38.
37 you have
Double
mentioned.
ଲେଖା ହେଇଯାଇଛି ସେ ସେପଟେ ବି ଟିକେ ଇଏ ଅଛି ତ ସେଇ ପାଇଁ ଦିଟା ସେ conclusion part ଟା.
Acha, 37, 38. That is page 240.
240, my lord.
Yes.
We have also given, my lord, list of citations along with copies of citations.
Please give it in a pen drive so that it would be.
Judgment, that I'll supply. This I'll give.
Okay.
I'll supply, my lord.
Yeah, that would be helpful if I
Yes, my
put
lord,
it
I'll
in-
supply.
That would be better. Okay, मैं ये करूँगा anyway pen drive में, okay? Yes, Mr. Mishra.
With respect to paragraph 7A.
Respondent division. Okay.
Respondent.
आपण का मत सेम पेज नंबर उड़ा टीपो.
Page 12 to 18.
Just issue number मते कौन था? Page 12 आरंभ.
Pleadings आरंभ ହେଇଗଲା. Issue ରହିଛି page 19.
नहीं मु बाकी उड़ा देखी मते issue आरंभ करी चुनी कोड सेट कौन?
8, 9, 10, 11, 12, 13, 14 and 34.
कोड आरंभ करी चुनी मते टी कौन? हाँ सेटा कौन?
Page 12 ରେ ଆରମ୍ଭ ହେଇଛି pleadings.
हाँ नहीं 19 नु issue को आपण डील कर चंदी राइट? ओके.
Page
So
12
से
ରେ pleadings ଲେଖିଛି.
हाँ प्लेन टा होची पेज केते?
12 ରେ pleadings respective party.
ओके गला 12
And page 19 ରେ
हाँ इशू आरंभ ହେଇଛି डील कर सेठी ला 4 ही कहि दियंतु. अच्छा 4 PO2 14 and 34 एटा आपण स्टार्ट करिसेंती पेज 19 नु. ठीक.
नंबर किंतु pleadings आरंभ ହେଇଛି 12 नंबर.
हाँ नहीं पेज 19 नु से इशू गुडा का आपण डील करिसेंती आ होए ताको एटा को पर्यंत कंटिन्यू करिछि.
Page 189%.
189. Okay, just a minute. Let me see that. Okay, then
Pleadings with respect to paragraph 7B starts from page 190.
नहीं तारो इशू अनुଯାयी लिखी ना.
अच्छी पेज 196.
अच्छा इशू
Pleadings आगे कर दूं तो 190 की सुविधा होगा.
अच्छा प्लीडिंग टा हला 190
issue starts from page 190.
नहीं से इशू गुडा केते नंबर गुडा मते कोन
196 पेज रे
हां
15 16 18
15 16 18
19 20 and 35.
19 20 and 35 एटा आरंभ करछन्ती आपण पेज नंबर केतेरु 190 196 रु इश्यू के को पर्यंत कंटिन्यू करछि 305 okay then
pleadings with respect to paragraph 7C
pleading हला next pleading हला सेटा केबे 306 ना 306
ରୁ start ହେଇଛି pleadings
हां मु onwards लिखि दउची सेटु जणा पड़ जिवो हां
and issue starts from page 321
नहीं को आगे इश्यू नंबर उडा कोन
issue 17
17
2133
तेती हां सेटा आरंभ करछन्ती आपण को पेज रु
এটা করলো page 321
321
pleading 306
हां प्लीजिंग टा लेक्चर लेन
issue 321
21 नु केत को पर्यंत
375
okay
then pleadings with respect to paragraph 7B সেটা সে 375 পেজ ରୁ ଆରମ୍ଭ
375 onwards आरंभ होइछ तापर इश्यूटा पुनी केबा केतोला आरंभ को थ्रू को इश्यू रा
382 नंबर पेज रे इश्यू 22 23
जस्ट अ मिनट 22 23 24
25 26 27 28
जस्ट अ मिनट 25 26 27 28
30
हां
and 33
30 एंड 33 ये आरंभ होइछ आपनकर पेज नंबर
माइनर 382
382 हां को पर्यंत जाइछि
407
okay next
then my lord paragraph 7A from pleadings
प्लीडिंग तापर आरंभ होइछि 407 रु ना 408 रु हां onwards लिख दउछि इश्यू
starts from 415
नहीं नंबर उडा कोन दे इश्यू
415 नंबर पेज रे अछि
जे म आगे नंबर इश्यू नंबर उडा कोन
28 30
जस्ट अ मिनट 28 पूरा कहिले से दबणे जो दीटा अछि अच्छा हला 28
28 30 31 32 33
32 एंड 33 एटा स्टार्ट हेछि को पेज रु
415 पेज ରୁ इश्यू
450 इन रु को पर्यंत जाइछि
फोर 451 पर
451 इश्यू नंबर 3
451 नंबर पेज ରୁ start
451 आरंभ हेछि टिल एंड
केवल 1 2 नथिबो आ सब कवर हे गेला
रोन 4 टू हेले अच्छा एक दुईटा देना दी किछि लेखिना एटा फॉर्मल मेंटल एबिलिटी दैट इज नॉट ओके सो 4 14 गला देन 15 16 17 18 19 20 गला देन 21 गला 22 23 24 25 26 27 28 गला 29 टा कोड गला 29 टा कोडी डील करना थी कहलेनी इश्यू नंबर 29 टा कोन बाहर कर 29 dauchi whether mentioning the name of Mauja as next page Patapur instead of Patapur in Cuttack district creates any confusion or not. That was the specific देना दी मत कहले नहीं तो मुझे ता ऊपर प्लीडिंग भी अच्छी आपणकर रिटन स्टेटमेंट अच्छी साक्षी भी कहिसंती तेणु आपण डील करना ता ऊपर
My lord ଅଛି 396 28 ପରେ ଅଛନ୍ତି।
अच्छा हो ठीक है
28
28 29 30 31 32 and 33 एतिक तो 415 टू 451 पेज भीतर रही
ଆଜ୍ଞା
ओके देन 30
396 ନମ୍ବର ପେଜ
सेटा गोटे स्पेसिफिक कर दी जंदी
ନାଇଁ 28 ସାଙ୍ଗରେ ଅଛି
28 संगे मिसी जंदी
28 29 30 33
हां
ये ଗୋଟେ ସେଟ୍
ना हेडिंग दी जंदी सेही चारटा रो
ଆଜ୍ଞା heading
ठीक है
ତାପରେ ଆଉ ରହିଲା
आवला 33 गला 34 गला गला 35 रहला 36 37 37 टा पड़ला 36 37 से 38 ऊपर किसी देना स्पेसिफिक मते whether the election of so and so void and entitled to these are general relief of sort. You have given that pen drive, na?
Yes.
Okay.
So I'll give Miller
today itself.
Supply to just within half an hour and supply.
So take down. So I'm closing it. Lekhundu. Land and Council for the election petitioner. So also Land and Council for the respondent. File their written note of argument, which are taken on record, and they have exchanged the written note of argument between them. Written note of arguments are taken on record. Copies are. Hearing close, judgment resolved.
Lord, also list of citation also.
As a list of citations.
Filed on behalf of principal.
All right.
Deeply approached. Note of argument is citations.
I've seen.
Say
written of citation along with citations. No, it's all right. Yes. All right.
Thank you, Lordships, for such a
many thanks that you have given me some breathing time to prepare the judgment. All right.
Deeply obliged.
Pardon to mention, my lord. Last item, my lord, is the fresh admission wrongly listed as admission, my lord. I pray, my lord, let it come taken off, my lord, before I.
Fresh admission.
My lord, it is a fresh. Only copy not served that day, my lord. I have already served the copy.
You have received the copy, Mr. Das?
Yes, my lord, I have received.
So, what is the condition here?
I am in virtual, my lord.
Last item. Last item.
13(1)(e). Disproportionate assessment.
Sentence is imposed. RI
2 years.
2 years. Fine is 10,000. In default to undergo RI for 3 months. Okay. 13. You are on bail during trial. All right. Mr. Das, you have already filed your appearance memo, right?
I will file by the end of April, my lord. Your lordship directed.
But your name is appearing in the cause list. Your name is appearing in the cause list. That is why I asked you that you have perhaps entered appearance in.
Yes. My lord, on the last occasion, copy was not served. I was present in the court itself.
Okay. All right. All right.
My lord directed
Mr.
the
All right.
registry to
Saubhagya Kumar
reprint my
Das,
name.
Land Counsel for the appellant, Mr. Sanjay Kumar Das, Land Standing Counsel for the Vigilance Department. Admit, call for the trial court record. Bail application लिखी हुई, he was not arrested during course of investigation. No chance of early hearing, bail allowed, stay realization of fine. Free copy of the order be handed over to Mr. Das, and he will file the appearance memo by end of swan-soon. Okay. Yes. That is
Obliged.
item number 50. Yes.
Item number 2.
my lord. In this appeal, I have challenged, the appellant has challenged the order dated 6/1/2024, passed by the additional session, the second additional session judge, the first additional session outla. While in rejecting the bail application of the appellant involved in the case under section 417, 493,
3 SC/ST Act is there, so notice has been issued. No, man. First time it has come. All right. Since one of the offence is under section 31X of the SC/ST Act, let the Land and Council for the state send notice of the appeal memo along with the annexures to the inspector in charge of Bisra police station for its service on the informant, that is respondent number 2 in Bisra PS case number 119 of 2023. Land put up this matter week after Kordiandu. Land Council for the state shall produce the case diary and obtain instruction about the criminal antecedent, if any, and also produce the confirmation letter regarding service of notice on the informant. So your matter heard Mr. Satya Pada in the virtual High Court at Sundargarh at Raurkela. Your matter will come on 19th. Yes.
Item 8.
Change of nomenclature, okay. IA से चेंज हेले जीव बीएलएपीएल कोडी जोटी आसीबो बीएलएपीएल से ता नोटिस पठेबे एटा खाली मु फॉर्मली चेंज करि देली नोमेनक्लेचर टा से it has to be registered and it is to go to the bench who is dealing with BLAPL matters. Yes. 9 time is extended and 10 also time is extended, intimate to the concerned court. Yes.
Item 11. Item 14.
May I please, Lordship? My lord, the appellant convicted under section 498 304B of IPC and the section 4 DP Act and sentenced to undergo arrest for 7 years under section 304B and to pay fine of
Maximum sentence is 7 years.
And he is in custody. During trial, he was on bail, arrested on 23/3/2017 and by direction of the Honorable Court released on bail 21/12/2018.
କେବେ ଗଲେ
21/12/2018 ଅର୍ଡରଟା ହାଇକୋର୍ଟ ଅର୍ଡର
ଆଗେ କଷ୍ଟଡି କେବେ ଗଲେ କୁହନ୍ତୁ
23/3/2017
23/3/2017 ରିଲିଜ ହେଲେ
ହାଇକୋର୍ଟ ଅର୍ଡର ହେଲା 21/12/2018. Now he is in custody from the date of judgment, that is since
8th January 2021.
No, 4 years 9 months total.
4 years 9 months. 7 ବର୍ଷରୁ 4 years 9 months ହେଲାଣି. Mr. Das, he is the husband.
My lord.
Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that out of 7 years of substantive sentence imposed by the learned trial court, the petitioner has already remained in custody for 4 years and 9 months. And there is no chance of early hearing and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail. So bail allowed, stay realization of fine. Yes. Okay.
Item 15.
May I please? Last occasion, Lordship has sought for a report from custody jail.
What is the sentence imposed?
20 years. 20 years.
20 years for the offense?
376D.
Acha. What sentence you have under?
6 ବର୍ଷ 8 ମାସ.
6 ବର୍ଷ ହବନି, half sentence ନହେଲେ gang rape. Either merit ରେ ଯଦି ଅଛି କୁହନ୍ତୁ, ନହେଲେ merit ରେ reject ହେଇଯାଇଛି already.
Not rejected. I am praying for interim bail.
Why? On what ground you say? On what ground? Any element of anybody or the petitioner's element?
No, I already filed my lord for bail.
IA you have filed for interim bail. There is no such ground like medical element of anybody.
No.
So you have not undergone half of the substantive sentence. Argue the matter on merit. If you get the bail, it's okay. Otherwise, that bail can be granted after if half of the substantive sentence we will consider. Otherwise, gang rape case on merit, if you get bail, it's all right. Argue the matter.
There are 2 appellants.
Yeah.
One, your lordship has granted one appellant bail as because he is juvenile, and the certificate come from the superintendent from whom that his conduct is good.
That's all right. How can you yourself claim parity with a juvenile?
There are no parity, my lord.
So then the victim has implicated both of you in the gang rape.
My lord.
So what is your criminal antecedent?
No antecedent.
Your bail application was earlier rejected on merit.
No bail application was filed.
So it is first time you are moving the.
My lord. In appeal bail, I have sought for the bail.
All right, you get the custody certificate. We'll see that.
Custody certificate.
Custody. Achi. Kete ବର୍ଷ ଅଛି?
6 ବର୍ଷ.
Reject ହେଇଯିବ 18/4/2022 ରିଜେକ୍ଟ ହେଇଯିବ
merit ରେ ମନା କରୁଛନ୍ତି, ମୁଁ ପଚାରୁଛି ସେଇଆ।
consent not the IA.
18/4/22 ରେ ରିଜେକ୍ଟ ହେଇଛି। ଆପଣଙ୍କର 2 ଜଣଙ୍କର ପାଇଁ ଆପଣ ବେଲ୍ ଫାଇଲ କରିଥିଲେ, ରାଇଟ୍? So,
Yes, Lordship. As because he is juvenile, he is
ଯାହା ବି ଆପଣଙ୍କୁ କଣ ପଚାରିଲି କଣ ଆପଣଙ୍କ ବେଲ୍ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି ଆପଣ କହିଲେ ନାହିଁ ଆପଣ କହିଲେ ସେ କୋଆକ୍ୟୁଜ ସେ ଜୁବେନାଇଲ ବେଲ୍ ରେ ଯାଇଛି ତ କହିବା କଥା ନା ମୁଁ ଆଗରୁ ଫାଇଲ କରିଥିଲି ବେଲ୍ ଟା ରିଜେକ୍ଟ ହେଇଛି
sorry, ma'am.
Right, Land Council for the state has produced the custody certificate which is taken on record. Put up this matter in the month of April 2024 for consideration of the bail application. Yes, next.
Item 16.
May it please your lords. Conviction under section 376. Sentenced to undergo RI for 7 years and 7 lakhs rupees.
What is the relevant page of the judgment?
Judgment is that the relevant page 23.
Sentence is RI for 7 years, fine is 7,000. In default, to undergo RI for 7 months.
Again.
You were on
bail during trial except 1 month, but in custody since 18/11/21 when the judgment was passed.
Yes, you are on bail.
My lord. No, I was on bail during trial.
Yes.
Except for 1 month. And since 18/11/21 when the judgment was rendered, thereafter he is in custody.
18/11/21 means it is 2 years and 11 12 1 so Dimas aguru kon mase roche. So it is 2 years 3 months.
Well,
so Mr. Das, so 7 years 7,000 and in default 7 months. Today is also 7, date is 7. So what do you say? Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody during course of investigation, and 1 month after he remained in custody, he was released on bail. After pronouncement of the judgment on 18th November 2021, he is in judicial custody, and as such he has remained totally custody for period of 2 years and 3 months. And since it's a criminal appeal of the year 2022, there is no chance of early hearing. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail and place the evidence of the victim PW4 and the doctor PW5. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced, sentence imposed by the learned trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine. Yes.
Item 17.
Yes, Mr. Jinnah.
Item 18.
Petition.
Mr. Dwivedi,
Yes,
you,
my lord, there is a petition.
huh?
In noting the petition I am filing. To engage,
That is all right. You are filing wakalatnama?
already filed that.
এই ভিনামা আছে দেখিলে। All right. Peruse the prisoner's petition at flag C, in which prayer has been made for engagement of Mr. Suryakant Dwivedi in place of Mr. B.P. Chwal Singh. Mr. Dwivedi has already filed Vinama, which is accepted. The names of Mr. B.P. Chwal Singh and his associates shall not be reflected in the cause list. Yes, sir, we can ask.
Sentence from the conviction and sentence is my lord 20 years under section 376, running page 47. When it has come, not admitted.
Yeah?
It is not admitted.
Oh, I listen. Yeah.
Defect
अच्छा order number 1 टा कौन की defect कौन रही ना 5D टा माने state copy
I
have received my lord. अच्छा the land council for the state submit that he has received the copy of the appeal memo along with the impugned judgment and copies of the interim application. Therefore the defect number 5D is removed. Stop. Had admit call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copies to be supplied to the region. Yes, actually the answer deposition copy to annex कर दीजिए. All right.
This is required to be because 373.
Acha, since one of the offense under which the appellant has been found guilty is under section
376(3), man.
376(3) of the Indian Penal Code. Extra copy बाकी usual order कर दें. Yes, next.
Item 19.
Mr. Patnaik, Ananda Narayan Patnaik, Nadi, Syam Manohar Lekhaiji, engagement of Orissa Manohar is also not there. His name is there. All right, pass over. Next.
Item 23.
Conviction matter 376. Do I know that? You are at 15 years only. After 6 months, matter FIR has been lost.
So it is 15 years in then. And
after 6 months of occurrence, matter FIR has been lost. After date of occurrence is October 2014. And date of FIR is 3/4/15.
you were on bail during trial.
No.
So how many years you are in custody?
4 years, 10 months.
Who is the victim?
PW 4 months.
4.
PW 4.
Dear trial court record. Deposition copies you have supplied?
Yes, ma'am.
Victim, when she deposed in court, stated her age to be 20 years, but stated that the occurrence took place 6 years back. So that means she was 14 at that point of time.
After 6 months of occurrence, he has given the FIR matter. October 2014 date of occurrence. Date of FIR.
But she has stated that she became pregnant and told to her mother 2 to 3 months after the incident.
May please your lordship. Item 26. The appellant punished under section 20B2C sentenced to undergo RI for 12 years. And minimum punishment might not 10 years, but sentenced to undergo RI 12 years imposed. So my case is not coming under section 32B, my lord.
He has not taken into account 32B, but imposed 12-year sentence.
6 factors is not coming. Those 6 factors is not coming.
ये देखिए NDPS Act. Okay, use or threat of use of violence or arms by the offender. The fact that the offender holds a public office and it takes advantage of that, okay. The fact that the minors are affected is okay. Offense is committed in an educational institution, social service, immediate vicinity of such institution, okay. Belong to a organized international or any other criminal group which is involved in. Fact that the petitioner is involved in other illegal activities facilitated, okay. Is there any other, how do you, because if you are sentencing a person more than the minimum sentence is here 10 years,
Right.
20B2C, then it should come under any of these clauses, A to F. But he says that none of the clauses are applicable. So the minimum sentence should be 10 years in this case. And he, according to the half of the sentence, he has already undergone. What is your sentence? 5 years?
5 years, 2 months, 13 days.
5 years, 2 months. So, is there any other criminal antecedent as per your instruction?
That I have received, but there is no criminal.
There is no seal. And this man is a local person?
No, he is not a local person. That is the only difficulty. He's from outside.
Then have you obtained instruction whether this address is correct one or
No,
not?
that is the address will not.
Correct.
No, address is not correct because when he has filed the anticipatory bail, we have inquired, but he has not found in the place.
No, we leave that anticipatory bail. Now you
Yes.
take instruction about this particular address.
But whatever I have taken instructions, he has no criminal antecedent. That is
No,
what
that is one aspect. But
Yes.
that is to be because once he's an outsider, we
Yes,
used
that
to
is
take
what-
instruction
Yes.
first about whether the address is correct or not.
Yes.
Then second is he has to furnish the local surety. So for that you obtain instruction. The Land Council for the petitioner submitted that since the Land Trial Court has not taken into account clauses A to F of section 32B while imposing higher than the minimum punishment of 12 years. This sentence is not sustainable in the eye of law. And if 10-year sentence is imposed, then the petitioner has already undergone sentence of 5 years and 2 months. The Mr. Tusharkant Satpathy, Land Council, has produced the Land Senior Standing Council for the Directorate of Revenue and Intelligence has produced the written instruction received from a superintendent of police called Rebadi, which indicates that there is no criminal antecedent against the petitioner. एटी लेखा ही तो ना प्राप्त रिपोर्ट अनुसार अमित कुमार जस्ट ए मिनिट आसलो से कॉस्ट टाइटल क्वेश्चन अमित कुमार पुत्र माने बापा ना होची रामपाल ठीक अछि निवासी होची आनंद राइट थाना होची बाबल रेखाइची जिला रेवड़ी so it has been they have stated the address is correct.
Yes.
So now you furnish this local surety to this. The Land and Council has produced one so in which the address of the appellant has been mentioned, which tallies with the cost title address of the appeal memo. Let the Land and Council for the appellant provide the names, address, and documents of two local sureties who are interested to take the petitioner on bail. To Mr. Satpathy, on receipt of which instructions shall be obtained regarding the authenticity of the documents and genuineness of the bailers. Put of this matter. केबे देबे आपण तांकर ना ठिकाना आउ से पट्टा या वोटर आईडी कार्ड ए सॉरी से आधार कार्ड एगुड़ा सब दियंतु देले से कंसर्न पुलिस स्टेशन जरिया रो से लोकल सिक्योरिटी करो जो पीएस हेतिबो सेटु नै जिवे इंस्ट्रक्शन आई एम पुटिंग दिस मैटर ऑन 26th of February 2024
लोकल सिक्योरिटी एट करा
yes 26th February 2020 एटा को टेकन ऑन रिकॉर्ड कर देबो
सर्टिफाइड कॉपी सर्टिफाइड कॉपी नॉन से विश्वास करिए ना
what do you want
कॉपी सर्टिफाइड कॉपी
of this order okay urgent certified copy
item 27
May I please the lordship. My lord, I am appearing on behalf of Mr. Amulya Panna. On sentencing under section 21C of the 29 of NDPS Act and prescribed punishment 10 years. 10 years and imposing fine of rupees 1 lakh.
yes
No, the deposition copies have not yet been served. Last occasion, your lordship directed them to serve the deposition copies.
So Mr. Counsel, there was a direction to supply the deposition copies to the Land and Council for the state.
And a copy has already been served, but the memo has not been filed.
Kahaku dele?
So far, I have got the instruction from Mr. Panda. He said that the copy has already been served to the Land and Council.
Or kon tanka pakhare nahi to you have you got any documentary proof that anybody has received or any there is a could have been filed in the AG office itself and a receipt could have been obtained.
Tomorrow I will solve the copy.
All right. Land Council for the
My lord, one thing. My lord, in order dated 21/6/2023, in another order has been attached. That is by CRA number 552 of 2023. 552 of 2023. That order has been attached in this case. Order dated 21/6/2023.
ଗୋଟେ ତ ଅର୍ଡର ଅଛି 21/6/2023 ର ଛୋଟୁ alias Sheikh Jamir
that CRLA 553 lordship
553 ର
but that order was attached on 21/6/2023 552 by the IA number
ଆଉ କିଛି ତ ଏଠି ନାହିଁ ଏଠି
IA number 1220 1221 ସେ order ଟା attach
କିଛି ନାହିଁ ସେ ଆପଣ କପି ଦିଅନ୍ତୁ deposition copies as per the order dated so and so deposition copies have not been supplied. Land Council for the Mr. Guru Prasad Behera, Land Council appearing through virtual High Court, Baleshwar, submit that he will supply the deposition copies by Monday. Put up this matter in the week commencing from 19th February 2024. Yes.
Okay.
This matter to come along with like the number 573 of 2023. Okay. Yes. Mr. Panda.
My lord.
Last occasion, my lord also directed regarding the withdrawal of the other 3 petitions that is tagged with the criminal appeals. Criminal appeal. My lord, in last occasion, my lord directed there are 6 criminal appeals. In 3 appellants, 6 criminal appeals. Earlier 3 and at present 3. Earlier 3 appeal, they have also filed a petition for withdrawal of that appeals. That is there. They have also the
Wait, just a minute.
the withdrawal petition is there.
So, अच्छा, okay. लेखंदु CRLA number 742 of 2023. Second item टा देखो हला that would have filed withdrawal petition. Peruse the prisoner's petition at flag D for withdrawal of the CRLA. Prayer is allowed. CRLA is disposed of as withdrawn. Hela. Same कर दियंतु in 743 withdrawn and 744 withdrawn. Hela. Now we are taking off the first one.
777.
That is 777.
Sir.
And it is mentioned that as per SR, you have not removed the 2 defects. One is 5D per of the state copy. The other is 5E. So,
My lord, the 3 connected appeals are there. I have already served 1 copy. That is 779.
ଆପଣଙ୍କର
Okay.
କୌଣସି ପିଟିସନ ର ଗ୍ରାଉଣ୍ଡ ଯଦି ଅନ୍ୟ ପିଟିସନ ରେ ଅଲଗା ହେଇଥିବ ତାହେଲେ ଗୋଟେ ଆପଣ କେମିତି ଭାବୁଛନ୍ତି ଯେ ଗୋଟେ ପିଟିସନ ଦେଇଦେଲେ ସେଟା ତିନିଟା
But because,
appeal କୁ cover କରିବ?
sir, because entire 3 appeals are arises out of 1 case.
Maybe the ground may be well, how they will maintain the
Yes, sir.
records?
Then my lord may taken up the last matter.
And you have
Sir,
not paid the High Court Bar Association fee of ₹50.
Sir, can it be taken up 779? I think that is
also copy has not been served.
The learned counsel for the appellant shall serve the copy of the appeal memo and along with the impugned judgment and copy of the interim application, and also remove defect number 5E within a period of 1 week. Put up this matter in the week commencing from 26th February 2024. Same order for the
779 well, I think that is defect free.
Wait. ସବୁଥିରେ ଅଛି 5E ରେ SR not removed. ସବୁଗୁଡା 5E ମାନେ 50 ଟଙ୍କା ଦେଇନାହାନ୍ତି. Yes. ଏଟା ସବୁ ଆସିବ 26 ତାରିଖ 26/2. Yes.
Item 29.
Yes, Mr. Das.
May I please lordship? Yeah.
Lordship, and he was on bail, Lordship, during the trial period, Lordship. The conviction part is in
operative part question.
42 page of judgment, 52 running page, my lord.
Kalia alias Kalandi, 7 years, fine 20,000.
Yes, Lord.
307/34 in default RI for 6 months. Okay, then you were on bail during trial?
Yes, Lordship. Page 12, my lord. That is there in the judgment also. Judgment or second.
Yes, arrested on so and so, bail which you are granted. Then who is the injured?
My lord. PW1, Lordship.
PW1?
Yes, Lordship.
Doctor?
My lord. Janagi, the informant is PW1, Lordship.
Injured ki
injured PW3, Lordship. Ritesh Palai. I'm sorry, Lordship.
PW3.
Yes,
who is
Lord.
the doctor?
PW3 is the victim, the injured, my lord.
Victim.
Doctor is PW5, Lordship.
PW5.
Yes, Lordship.
So, what injury the victim or injured has sustained?
Lord's
What injury? 2, 3, tinta injury. Simple injury, but final opinion as to the nature of injury was reserved. Referred to SC Medical College Hospital, awaiting report. Okay, first injury is in the vital part of the body. First injury tell a cut injury, 14-inch length. Deep on the, okay. What is the weapon of offense, Mr. Mishra?
My lord's sword and bhujali. This present appellant assaulted with a sword as per PW3, and another accused assaulted with a bhujali on the chest, back, and left shoulder.
How many accused persons participated?
Two. 3 accused person he has named, my lords, PW3. However, the assault part is only attributed to 2 accused persons.
Kalia assaulted me by means of a sword.
Lordship.
This man is
Kalia, my lord. This man is Kalia, my lord.
So, and Gunda assaulted me by means of bhujali. Assaulted on the so and so. I sustained bleeding injury, fell down unconscious. Villagers protested, accused persons fled away, shifted to Angul Hospital, and then referred to SCB. I regained sense and they have a discharge from on 39/2010. घटना के बीच ना
19/9/2010.
19/9/2010, my lord. 10. Okay. Because that would not even come within the definition of previous injury, because 20 days of unable to attend the ordinary pursuits. That is one of the criteria for determining whether it's a grievous injury or not. The doctor has stated that these injuries are simple in nature. So where is the material that it's a grievous injury? He might have been undergoing treatment at SC Medical College, but there is no evidence that the injury, because your doctor has stated that all the injuries were simple in nature. And he reserved the final opinion in respect of particularly what the gote injury pain,
assault on the chest,
right? But you should have proved any documentary evidence from SC Medical College. Have you examined any doctor who treated the injured at SCB, or any report from the SCB has been proved? SCB ର କିଛି report ପ୍ରମାଣ ହେଇଛି କି?
No other doctor has been examined, my lord. No.
Huh?
No, my lord. No other doctor has been examined.
ଗୋଟିଏ ଡକ୍ଟର ତ ଆଉ କଣ?
Yes.
Say PW5G, Sukanto.
No medical report from SCB is also there.
No medical report, Lord sir.
All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner was on bail during trial. He has never misutilized the liberty, and after pronouncement of the judgment on 21/8/2023, he has been taken into judicial custody. There is no chance of early hearing of the appeal, and balance of convenience is in his favor. He further submits that PW3 is the injured in this case, and though he has stated that the petitioner assaulted him by means of sword and another co-accused assaulted him by means of bhujali. But the doctor bracket PW5 has noticed 3 injuries on the person of PW3 and opined the injuries to be simple in nature. Though PW5 referred the PW3 for medical examination to SC Medical College Hospital, but neither any doctor from SCB Medical College nor any document from the said hospital has been proved. So there is no material that the injury sustained by the injured bracketed PW3 were grievous in nature. Moreover, the PW3 was undergoing medical treatment for from 19/9/2010 to 39/2010, and therefore it would not attract clause 8th of section 320 of the Indian Penal Code. And therefore, the bail application may be favorably considered, and counsel for the state place the evidence of the injured, so also the doctor. Considering the submission, nature of accusation, nature of evidence adduced during trial, sentence already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine.
Obliged, my lord.
Yes.
Item 31.
Yes, Mr. Sahu.
to serve deposition copy, my lord. ମୋ ପାଖରେ 1 to 5 ର deposition copy ଅଛି including victim and parents. Lordship,
କୋଉଟା କହୁଛନ୍ତି
item 32.
32 ଟା ନେକ୍ସଟ ୱିକ୍ ରହିଛି।
deposition copy ଟା permitted to
ଫାଇଲ କରିବେ
ନା ନା ସେଟା ମୋ ପାଖରେ ଟୋଟାଲ ନାହିଁ ରେକର୍ଡରୁ ନେବି।
ରେକର୍ଡରୁ ନେବେ। ରେକର୍ଡ ଏଠି ତ ସାର୍ଟିଫାଇଡ କପି ମିଳିବନି କାରଣ ଏଠିକି ତ ଜେରକ୍ସ କପି ଆସୁଛି। If you want to, because nowadays the original LCR is not coming here. So if you want to obtain the certified copy, you can obtain it from the trial court. Here now only we are getting the Xerox copy. Hala? So we obtain the certified copy. Yes. On the ground of ill health of the petitioner. the instruction. Yes, sir. कौन असला? What is this, Mr. Devasnan Das, item 41? What is the delay? Nadi.
Item 39 ମାନେ ତ continuation delay.
हाँ केते दिन कौन? एटा कौन criminal appeal माने कौन हो?
10 years ର implementation
खुली की दे. What is the
objection file
खुली की दे? एटा की 39 टा बार कर लो. ये फाइल आवर ऑब्जेक्शन। हाँ केते दिन डिले अछि? बाप रे 1325। ଆପଣ ବାରକୁ ଦିଅନ୍ତୁ ଟଙ୍କା ଦିଅନ୍ତୁ ସେ
ଗରିବ ଲୋକର ଆଦିବାସୀ
କୋଉ ଆଦିବାସୀ
ଆଉ 9 ମାସ ମାତ୍ର ରହିଛି ପଠକ ଆଉ ସବୁ ପାର ହେଇଗଲା 9 month ଆଉ
1325 दिन डिले ହେଲାଣି। ବାରକୁ ମିନିମମ୍ 5000 rupees ଦିଅନ୍ତୁ ତାହେଲେ ହବ ନହେଲେ ଗଲା।
ପୋଜିସନ ଗରିବ ଲୋକଟା ଦେଇପାରେ ଆଉ 9 ମାସ ମାତ୍ର ଅଛି କଷ୍ଟଡି।
କଣ ଗରିବ ଲୋକ ଆପଣ କେମିତି ଏନଗେଜ କଲା? ସେ ତ ଜେଲ କ୍ରିମିନାଲ appeal ଫାଇଲ କରିଥାନ୍ତା। All right, hard. So this is an application for condonation of delay. And counsel for the state has filed the objection. Since it's a case of conviction in which 10 years substantive sentence has been imposed, delay is condoned. Hard admit call for the trial court report. Interim application for bail and state will be considered after receipt of the trial court report. Yes, item number 43, my lord. The report was wait. 41 again.
40. I'm not in 40 my lord.
25 days, my lord. Huh?
I'm in 40 my lord.
Conviction under section 394 for under 5 years, 397 7 years,
delay condone कर दियंतु
307 10 years.
Admit कर दियंतु बाकी सब consider होगा after receipt of the trial court report. Deposition copy to be supplied. Now next one 42. Mr. Jena, कितने दिन delay?
Delay is 1 day, my lord. And convict.
अच्छा delay 1 day, delay condone, है ना?
Conviction is 10 years, man.
10 years deposition copy to be supplied is to be considered. Yet item number 43 टा कौन दो? 43 रे report हाँ। Appellant ନିଜର is in the medical treatment. Appellant ର treatment ପାଇଁ हाँ। हाँ तो ट्रीटमेंट तो ଚାଲିଛି ଅସୁବିଧା କଣ ହେଲା? ବେଲ ଲେଗ ନେଇ ଆଉ କଣ କରିବେ? ଆପଣଙ୍କୁ ସେ ନେଉଛନ୍ତି ଡାକ୍ତରଖାନାକୁ କ୍ୟାପସୁଲ ଆଣିକି ଦଉଛନ୍ତି ଆପଣଙ୍କର ପାଇଲ୍ସ ହେଇଛି। ଏଟା ଗୋଟେ ସେମିତି ଗୋଟେ ଇଏ ନୁହେଁ ଯେ ଆପଣଙ୍କୁ ଜାମିନ ଦବା ଦରକାର। ଅପରେସନ ସେଠି ତ ସେଠି ତେଲ ଫେଲ ଖାଦ୍ୟ ତ ବେଶୀ ନଥିବ ବାହାରେ ଆଇଲେ ଖାଇଲେ ସେଗୁଡା ବେଶୀ ଆଗ୍ରାଭେଟ କରିବ। ଦେଖନ୍ତୁ IN number so and so, this is an application for interim bail on the ground of ailment of the petitioner. The Land Counsel for the state has produced the report of the medical officer from which it appears about the nature of disease petitioner is suffering from and the medicines given to him. The report is taken on record considering the submission made by the Land Council pursuant so 1 month bail granted. Yes, next.
37 out of 10 years, 8 years, some odd days He is inside the custody.
Custody certificate আসছে?
My lord, I have got that custody certificate. Also, it has been reflected in the judgment, my lord. Your lordship straight away come to, that is the custody certificate. Come to page, my lord. 11 of my brief. Towards last. From 13/12/2015 till the date that is judgment, 7 years, 10 months, 8 days.
Yes, Mr. Judgment টা দেখুন।
37 টা। Page 11.
37 judgment ର second page କୁ ପଳେଇ ଆସନ୍ତୁ।
Page 11 ଟା। ये ଦେଖିଦେଲ। Running page 11 more paging ଅଛି।
ଦେଖିଲେ?
ଯୋଉଠି ଆଙ୍ଗୁଠି
13/12/2015 ଦେଖିଲେ date of custody। ଆଉ ବେଲ୍ ରେ ଯାଇନି।
No.
ତ ଇଏ ତ ଆଉ ଯାଇଛନ୍ତି କି ଏଠି ବେଲ୍ ଫେଲ୍ ଯାଇଛନ୍ତି?
No. First time. This is the first time.
8 ବର୍ଷ ହେଇଗଲାଣି। 10 ବର୍ଷରୁ। ଲେଖିଦିଅନ୍ତୁ 13/12/2015 custody, 8 years is already there, and keeping in view that ratio of the decision that Mohammed Muslim case well allowed sterilization of fine.
Oblige your lordship.
38.
Yes.
20B2C, my lord. 38, my lord. Is in custody in 3 years, 10 years in conviction, and 3 years in custody.
20B2C?
Yes, my lord.
Half of the punishment ନହେଲେ ରହିବ।
My lord, some days, my lord, we granted, my lord.
Next.
My lord, some days, 3 months we granted, my lord.
44. ये Mr. item number 44.
51 days delay.
हाँ?
51 days delay.
देखिए बाहर के लिए। Then admit, then bail granted, है ना? Sterilization of fine. Yes, item 45.
45 मतलब 34 days delay.
देखिए
34.
Wait. Yes, 63 days delay.
63.
And what is the
10 years
sentence
now.
here?
Conviction is 10 years now.
10 years.
NDPS Act.
All right, delay condone, है ना? Admit, deposition copy to be supplied, है ना? बाकी custody certificate to be produced. Put a date दे देवे. Next.
Next also 20B2.
Item number 46. What is the delay? Delay is 94 days. Okay, sentence is?
It's 10 years, my lord. That is also
20B2C. All right, same order. Delay condone. Hala? Admit. Baki also karo. Okay. Rest of the matter kal nahi aise.
May please lordship. My lord, always it is coming in the back. It is not eating. Can it be top of the list?
କୋଉଟା ଆପଣଙ୍କର କହିଲେ?
I don't know 40 my lord.
ଆଚ୍ଛା ଦେଖନ୍ତୁ କାଲି 40 ଟାକୁ ଟିକେ ଉପରକୁ ଉଠେଇ ନେବେ।